Good morning all. This hearing is in the matter of CFI 029-2025 and is being held via video conferencing before His Excellency Justice Roger Stewart, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Watson, Farley and Williams. Lead counsel is Mrs. Charlotte Vigilani. The defendants are represented by Hamdan Al-Shamsi lawyers and legal consultants, and lead counsel is Mr. Lucas Biersigal. Thank you, Your Honour.
Good morning, everyone.
Good morning.
First of all, thank you for the schedule of particulars and the response to it and the skeleton arguments and the statements of costs, although I confess that I have not had the opportunity to look at those latter documents. So far as today is concerned, there are a series of applications before me, most notably the original contempt application and the varied contempt application, the extension of time application, the discharge application, the contesting jurisdiction application. I've read what you both have to say about the matter, and I note in particular the claimant's contentions that I shouldn't hear the defendant before determining the contempt application. I don't think that's convenient in the circumstances of this case. In particular, it seems to me that it is sensible to hear the defendant, if necessary, on a de bene esse basis in relation to the application to discharge, because it seems to me that even if I were to find that he was in contempt, the fact that the original order had been made in breach of a duty to give full and frank disclosure, or in circumstances which would be discharged, would be relevant to contempt application, and therefore it seems to me to be unrealistic to suppose that one could determine the one without the other. It also seems to me that as a matter of timing, it's convenient, as it were, to start with the beginning and determine whether the original order should have been made, and if so, in what form. I therefore propose to hear argument in the following order. First, I will hear the parties in relation to the application to discharge and in relation to the jurisdiction arguments, which seem to me to be at least linked together. I think it would also be convenient in that to address the question as to whether or not, if I were to take the view that the original application or the original waiver ought to be discharged, it should be reimposed. So I'll hear our arguments in relation to that. I will then hear the arguments in relation to contempt. And it seems to me that if one deals with those matters in that course, we will sweep up all the various matters which we need to deal with. Now, my intention is that, if possible, I will give a judgment on all matters today. That may not be possible. It will depend in part on the points which are put forward and whether I need time to consider them. But with that end, what I am aiming to do is to conclude argument on all points by the short adjournment, that is by 1 p.m. Gulf Standard Time, and if necessary, I'll hear argument on further matters after the short adjournment, but that's the aim, so please tailor your submissions accordingly. You should also take it that I have read the skeleton arguments that you have submitted, but if there are particular points that you want to emphasise, you should of course do so, and if there are particular passages in the authorities which are relevant, you should also take me to those, although I may well indicate that I'm familiar with them at the particular point. In those circumstances, I think it is convenient, Mr. Fearseagle, for you to go first.
Apologies, Your Honour. Could I just make one point before we proceed further? There is also the default judgment application before you, which I would invite you to also determine today.
Where is that in the bundle, please?
So that is in the application tab. Let me just go to it. My mouse is playing up, I'm afraid. Can't seem to move my mouse at the moment, sorry.
I mean, I can't see that in bundle B, but I may be in section B.
It must have been put somewhere else, sorry.
Well, when was it issued?
I don't know if someone in my team, can you please pull up the application for default judgment on the screen, please? So here it is, and you can see it was issued on the 12th of May.
Has it actually been listed for hearing today?
I don't think it was officially covered in your last order, but I would suggest that it makes sense to be dealt with. It's also crosses over with the jurisdiction challenge that my learned friend makes, in the sense that he says he can still argue about jurisdiction. We say he can't.
All right. I will consider whether it's appropriate to deal with that today. And what I suggest we deal with it is that when you're replying to Mr. Fearseagle's submissions in relation to the first series of matters, you identify this, as will be apparent from what page is that of the bundle which you just?
It's 2596.
I do need to have, I'm afraid, not screen sharing. I do need to have the pages identified. So page what?
2596. I should say there have also been witness statements exchanged, or served rather, in relation to that application. One,
right. Well, when you get to it, you can identify where those are in relation to that.
Of course.
It would have been helpful for you to identify in your skeleton argument what the applications were as it was being put forward, Ms. Vigilani.
Yes, anyway. I did deal with it at the end of my skeleton on page 17 onwards.
Yes, I mean,
default judgment.
I appreciate that. When one is introducing a new application which hasn't been put forward and hasn't been listed, it might have been convenient to deal with it at the beginning. But anyway, there we are. Let's deal with that as we were. I was saying before Ms. Vigilani made her intervention that Mr. Fearseagle, I'll hear from you first. In relation to what you say about what were the breaches of the obligations of full and frank disclosure, you don't need to say anything in your opening beyond what you've said in your skeleton, unless, like last time, there is material upon which you rely which isn't contained in the skeleton which you're addressing. But I'm rather assuming that this time round everything material you want to say about that has been said. So yes, with that introduction, let's get going.
Yes, my speaking note was rather longer, but let me just, perhaps because it will save time, let me just take, if I may, Your Honour, just 30 seconds to look through my notes. If it's always nerve-wracking to just say, well, it's in my skeleton, but just give me a moment, Your Honour, because it might save some time if I take a very brief pause now.
Yes.
I gave, not only would I have said it in my skeleton, I gave quite a long introduction before we adjourned last time about the nature of the obligation of full and frank disclosure, and how this hearing was essentially an open goal by virtue of the fact that this is not a failure to comply with the duty despite some attempt having been made, but that there was no attempt at all. I know Your Honour already has that point, but I just want to start with it anyway because it only takes a few seconds. The first thing I want to just add to my skeleton is it was brought to my attention by my team after I put this in, that in my footnote 2 on page 1,
Yes.
I said that the court reminded Ms. Bijlani of the duty 3 times. I think more accurately the answer is 4 times. And if you look at H2,
Can you give me pages, please, to the bundle? I mean, I can find it by looking at H2.
yes, except unfortunately some things have been put in, which means that all the page numbers are put in recently, which means all the page numbers have changed. So just
right, I've got the transcript.
They shouldn't have changed. The page numbers at the end of just additional documents just been added on at the end of the bundle.
Which page are we on?
Yeah, let me just give you I'm going to come back to it, Your Honour, because my reference is duff. So I'll leave that. I'll leave that for now. In relation to the allegations that there was a breach of full and frank disclosure for the failure to include the part of the order relating to ordinary course of business.
Yeah.
This breach is all the more egregious in the circumstances of what occurred at the last hearing, which I wasn't able to put in my skeleton because I don't think you had at the time made the order that you approved the order or the minute of the order put in by the parties. We of course put in 2 different versions of the order. After the last hearing, I received from Ms. Bijlani a draft order which made no reference at all to any of the quite extended discourse we had had about the variation to the order on a pro tem basis. And so when I wrote back to her, thankfully I wasn't too tired that I didn't spot it, and said, well, where is this thing that we spoke about? She replied that that should not go in there. And then she attempted to massage the term of her concession into being relating only to the first defendant and the second defendant and shouldn't relate to the third defendant. I don't know whether that was a genuine confusion or not, but the point is of significance to this extent. Often, when faced with an allegation of full and frank disclosure, the applying party says, well, I may have made a mistake there, but that was just a mere oversight. And to the extent that I did make a mistake, you didn't come back to me when you got this order and say, can you put this in? And if you had, of course, I would have agreed. The opposite situation is true here, whereby we have an applicant that has flagrantly breached the duty. When they are told of the breach of the duty, assert that they haven't, and even then refuse the order to be amended on a pro tem basis. So it supports my client's case in a way that is difficult to envisage as more powerful, that this was a breach of the duty of full and frank disclosure, if you accept that you were misled in being told that that was the standard order, when in fact it wasn't, that is deliberate. And of course, if the breach is deliberate, then the consequences of that breach are far more serious.
Yes.
It is the case that in the response to the schedule of particulars of breach, that there remains no acceptance at all that anything wrong was said at that hearing, and it appears to be continued to be the assertion that the duty was complied with, again, notwithstanding that no attempt was made to comply with it. I made the point very briefly in passing orally, and I make it again now, that the corollary of the application of the authorities, which I know my Lord knows well, is that was an implicit assertion to you at the last hearing that had I been present, I would not have made any submissions to you at all about the nature of the case made against my clients. And in view of what I've said to you in writing, and I'm going to say to you today, that is obviously not a credible position to have taken.
Yeah.
A similar circumstance applies in relation to the bank guarantee. A bank guarantee, as I put in my skeleton, even on a bank, is a serious obligation. They excused themselves that obligation. And again, you know it was deliberate, because there is, as you know, in the schedule of undertakings, a provision that I set out in my skeleton, providing that for the discharge of the order, if certain of the undertakings are not met, and the example is the failure of the applicant to provide the guarantee. And that has been changed to failure of the respondent, or forgive me, in the event that the respondent provides security for the claim. So I suppose I make the broad point that in relation to the removal of the provisions for ordinary course of business and the decision not to include the obligation on the applicant to provide a guarantee in respect of their undertakings as to damages, these were plainly egregiously deliberate breaches of that and an attempt to remove sections of the order. Now, a learned friend says these are bracketed and therefore they are optional. And to the extent that she says that, of course, she is right, but they are optional to the extent that the court must consider whether to include them. And to the extent that an applicant removes them, I'm not saying they can't be removed, but if you do remove them, you have to tell the judge. And it is inconceivable that you would have made this order without a provision for assets not to be frozen to the extent that they related to the ordinary course of business. Now, I mentioned in my skeleton, I mentioned it orally to you at the first hearing, I put through my skeleton authorities, I mean, what quoted in a parallel in relation to Lackatamia shipping and how, I mean, it's sometimes it's difficult to find authority on it because it's this one, it's like what is the duty of full and frank disclosure? Sometimes difficult to find authorities on it because it's so centrally obvious. But I can take, my lord, to those authorities on why, on the purpose of a freeding order not being to provide security and not affecting assets.
You don't need to take me to the proposition that the purpose of a freezing order is not to provide security. Can you, sorry, just this is just bundle navigation. I had it, but I've lost it. I've got the claimant's response to your particulars. Can you just give me the page number of the particulars of breach? Because I seem to have mislaid that at the moment.
Yes, I have them separately, but I will let me just find them now. Your Honor.
The DIFC's remote facilities are wonderful in most respects, but we still have some grounds to go in relation to bundle and navigation.
I'm sorry, Your Honor, I've never looked at them in the bundle.
Right, don't worry. If I had them just now, I may find them again. But if someone finds the actual schedule of particulars with the bundle, can they just give me the number of it? What page is that? 2554. Thanks. Yes. Thank you.
There is one matter that I need to, I think, bring your attention to, which is a sloppy way that I have set this out, but I'll come back to that in a moment. If I start finishing and saying I haven't dealt with my stopping point, Your Honour, perhaps you'll remind me. I think the most significant thing that has occurred since the skeletons is that the respondent, the claimants now accept that the basis on which the claim has been calculated is not right. Now, they say, well, you look at these paragraphs in relating to the sum that is owing, and sure, there's a typo in there to the value of 2 million quid, but it's obvious and it doesn't change the amount that's owing. That is a partial and completely unconvincing answer to all of this. The suggestion, perhaps the easiest place to look at it is perhaps in my skeleton, and if we look at paragraph 41,
yes,
where I set out there the quotation from Mr. Sandilla's second witness statement. And it will not have escaped your attention that that second witness statement is sworn on the morning of what was supposed to be the first, or perhaps I think we describe as the first return date, where he says that there are UK gilts sold for 71 million. That leaves a positive balance of 6.5. And if you subtract the pounds principal loan in the amount of 61, and then £250,000 in early repayment charges, and the existing negative balance of 1.25 million, you get the positive balance. You leave a positive balance on that account of 6.5 million. Now, this is written by Mr. Sandilla. I know he's CEO of the first claimant. I don't know what his professional background is or what he does on a day-to-day basis. My own impression of this case, and we'll get onto this more when it comes to jurisdiction, is that the first claimant is essentially a broker, almost like a managing general agent for an insurer who writes business for one principal, being the head branches or family branches of EFG. Now, if you're a broker rather than a banker or a lawyer, that it is obvious that there is an arithmetical error there, and it's out by 2 million quid. And that's what I set out at 42, because if you apply the sums, you don't get to 6.5 million, you get to 8.5 million. And if you get to 8.5 million, then the value of this claim is whatever sum the claimants seek, minus £2 million.
Yep.
Now, the respondents, the claimant's response to me pointing this out in the schedule was to say there was no change, and when but they obviously looked at it rather more closely, because it was at the same time as my skeleton that they said they set out their case that this is just an obvious arithmetical error and there's no moment to it, and that is not either a correct or a fair characterization of all of this. If you have an arithmetical sum, you don't need me to tell you, my lord, that it's impossible to know where the number all you can say is whether it's right. It's not possible to say, well, I know that number should have been 2 million higher or 2 million lower, knowing where it is. And the fact that it isn't obvious is proven beyond doubt by the fact that this paragraph in Sandilla 2 is carried across almost verbatim to the particulars of claim. And if we were to look at that, my lord, we can see that in the particulars of claim on page 18 at paragraph.
Sorry, can I have the bundle reference, please?
I'm sorry. On page page 18, tab 3 of section A.
Is that page 18 of the overall bundle?
Yes.
Fine. So which paragraph?
Paragraph 9.5. And you see there.
Yeah.
It's exactly the same.
Yeah.
So although my learned friend says, well, this is obviously a typo, they've spent $600,000 looking at this case, but nobody seems to have noticed that there is this 2 million in the claimant's favour in there, and it is simply not possible to understand it in any other way other than that it reduces the claim.
So, we'll just to be clear about this, you're not, I think, challenging the proposition there's a typo here. There's obviously a typo here of some description or other.
There's a typo here of some description or other.
What you're saying is that it's not obvious what the typo is.
That's the first thing I'm saying, and you bring my first point to a conclusion. The second point is that this is not an ordinary margin call case. It's not pleaded in a way that can be understood by anybody reading it. In a margin call case, you say, we lent you this much money against this much security. Your security fell in value. We made a call on you. You didn't meet the call, so we sold your security. And the amount you owe us is X amount that we had lent you minus the amount that we managed to realise your security for. Or they don't realise your security. They pledged it, you've pledged it, they just say, we give you that back and you owe us the whole amount of our loan. We haven't got to sell anything you've pledged to us. Pay up. This case, they say they sold it. It's impossible to figure out from these particulars of claim how much they say they actually lent us.
Right, but sorry, I just want to understand how that. I got your point that there's obviously an error here because the sums don't work, but you can't tell what the error is. That point I've got. Yeah. What I'm missing is what your point is in relation to this isn't an ordinary marginal call case beyond your first case. What am I missing?
They don't say how much they loaned us.
Oh, I see. Okay. Yes, all right.
The way you calculate the liability.
Yeah. In other words, it's not possible for you to work out yourselves what they're saying is correct.
Exactly. They don't say, I lent you a tenner, I sold your security for £8.
I've got the point. So you can't see it from the individual sums, but moreover, you can't see from elsewhere within the document how the sum ought to be calculated. That's your second point.
Correct.
Yeah.
And the third point is that on what they have provided, it says the loan is repaid. If you go back to 41, forgive me, you are at 9.5, which is the same thing.
Yeah.
May I just take your honour through it quite slowly?
Yeah.
We sold the gilts for 71 million, leaving a positive balance on the pounds account of 6.5.
Yeah.
After subtracting the 61 interest and early repayment charges. So on the basis of 9.5, the collateral has met the loan amount. That's unsurprising because a bank will always leave quite a large margin. They don't want to be in a position where if you miss the margin call, they're out of pocket. So it is unsurprising. They say that the amount of the margin was insufficient to meet this particular percentage application that they provided, and that's why the margin could be called in. That may well be right. It wouldn't be at all surprising for a bank to demand a much larger margin than the security was going to give, because no bank lends on a one-to-one.
So I've got I think the point about 9.5, but then 9.6, the remaining 6.4 odd million or 6.5 odd million was exchanged partly in euros and partly in dollars to net off negative balance on those accounts.
Yeah, and you want pauses there. What accounts?
Yeah.
And how has this got anything to do with this loan?
Yeah. So your second point is in 9.6. Not clear what those accounts are.
It's not only is it not.
We'll just say not clear what those accounts are. And it's those accounts which give rise to a claim.
Yeah, exactly. 9.6 does not mean anything. I've spent more time staring at it than I care to admit. It is
okay.
And when you step back,
I've got the point. Now, then this was after netting off all other positive small account balances on different accounts. Again, you would say presumably unspecified, to a negative final loan balance in the amount of 3.3 just under 4 million euros, which was not covered by collateral. So what you're saying is that 9.6 is effectively saying that by a process which is unclear, the positive balance of call it £5 million becomes a negative balance of 4 million euros. But what's taken into account is as clear as mud. That's your point.
Exactly.
Your Honour, can I just intervene, because I feel we're spending an awful lot of time on this point. Mr. Jummer and Mr. Khan of Arj received regular statements telling them what's outstanding. I'm happy to put those before the court, but it's just a bit absurd to listen to submissions about a Swiss sophisticated bank pursuing litigation if no money's due. And Mr. Jummer knows exactly what's due, and he's known for many, many months.
Ms. Bijolani, I'm sorry. First of all, you will have the opportunity of responding. Secondly, these are particulars of claim on which you've told me you're seeking default judgment. And it is an obligation of particulars of claim to identify how you get there. I don't think I'm being assisted by you telling me that at this stage, on an application which, as far as I can see, isn't formally listed, you're going to put in further evidence saying effectively the defendant knows what's going on. And if you've got points, you can deal with it in due course. Yes, Mr. Fearseagle, all right. I've got your point that the particulars of claim doesn't really help in relation to this.
What I think's happened here is that he's missed the margin call. They've closed him out. His security has been sufficient to repay the loan in respect of which the margin call was made. But because they've closed out his position with the bank, they say he owes them other money. And I think that's what this case is all about. But I've figured that out from spending a lot of time looking at 9.5 and 9.
I mean, I've got your point on the particulars. So that's what you say in relation to this is just a typo.
Yeah.
Okay.
It's and I suppose the wrap up point to this is stepping back when it comes to the test of good arguable case. If you find against me on all these points and this case goes ahead, and assuming you don't find against me on default judgment, I'll be trying to strike this case out, or at least to strike out portions of it. And that really, forget is it a good arguable case? Is there a serious issue to be tried in circumstances where an applicant says this case does not make sense and is amenable to strike out a fortiori in relation either to full and frank or to discharge?
Yes, I mean, just to flag the obvious point in relation to this does look as if something has gone wrong. I mean, absent all other considerations, and assuming that this was there were no jurisdiction points and this was a claim being put forward, what you would expect in relation to this is effectively a request for information.
Yeah,
so
sure.
We don't understand this. You would be unlikely to strike this out without, as it were, at the very least, having given the claimant an opportunity to explain what's going on.
I accept that. Vis-a-vis the calculation of the sum, what I'm about to address you on now adds a different colour to it. But I accept. But I mean, taking it at the stage we are now, just on the sums here, does this raise a serious issue to be tried? Only by inference that a Swiss bank doesn't go after someone for 4 million euros unless they genuinely believe it's owed. I mean, that's the difference, isn't it?
Alternatively, that buried within 9.5 and 9.6 is an unexplained accounting mechanism, which would have to be explained in order for there to be judgment. But there is material saying this has taken place and we've got to 4 million euros. Which anyway, okay, all right.
Exactly. Well, I think your Honour and I are on the same page on that point. But yes, I agree. But look, I can tell you that on the documents that I have seen, i.e., everything that the claimants have provided, it is not possible to understand why it is said.
Mr. Fearseagle, I'm quite anxious in this case for reasons I just put forward to Ms. Bijolani. I feel both sides now had an ample opportunity to put in evidence whatever they want, and I'm quite happy for you to make submissions, but I think avoid telling me that on the documents you've seen it's not possible to do X or Y. If Ms. Bijolani says it is possible on documents before the court, she'll no doubt do so in due course. All right, let's move on.
Thank you, Your Honour. I think I need to massage one of the points I made in the skeleton, because I say here are my points of full and frank disclosure, and at the end I just say, and all of that is to do with good arguable case. I think rereading my schedule, which was put in some haste, there are points I make in relation to good arguable case that I think, if I'm looking at it again, have not been fully particularized in that schedule. That's obviously not the end of the road, because Your Honour, as Your Honour mentioned in his sort of introductory remarks, there's a question also about whether this order should be discharged or indeed continued, and so therefore I make these points not as an allegation of breach of the duty of full and frank disclosure, but nonetheless as a reason as to why the order should be discharged, because there is not a good arguable case. If that's a distinction I can draw now. Can we go then, please, in my skeleton to section at paragraph 46, which concerns the third defendant. And I just want to take you to some documents here.
Yeah.
Because I don't. This is a point that Mr. Sandilla says that Mr. Juma is liable because of a credit agreement entered into between the bank and Mr. Juma. And you will have seen that Mr. Juma elides the question of who is the bank. If we look.
So do you mean Mr. Juma or do you mean Mr.
Sorry,
Sandilla?
I mean Mr. Sandilla. I'm sorry, you're quite right. The question of who is the bank.
Yeah.
Can we look, please, at page 520, which is at E1. This is a reference that I missed at paragraph 4.7.47.1 in my skeleton.
Sorry, which page?
I'm sorry, E1 520.
Yeah.
And this is a reference I should have put in the skeleton 47.1. Paragraph 3. EFG
which Sandilla is this? Sorry, Nick.
This is 1.
Yeah. Yeah.
EFG Bank Limited, as also known as EFG Bank AG and EFG Bank SA. That cannot be right. Those are obviously different companies incorporated in different jurisdictions, which may well trade as the same group and all call themselves EFG. But the claimant, or the second claimant in this case, is EFG Bank Limited, and that is of importance when one looks at the corporate guarantee, the personal guarantee rather, itself. And if we could just turn to that, which is at your D7156.
Yeah.
You see there that this is an agreement between Mr. Juma and EFG Bank SA, not EFG Bank Limited.
Hang on, just make. Yeah.
And you see that there's, if you look on the third line of the substantive text, extended and renewed from time to time between the beneficiary and the company, dated 7th of April 2022.
Yeah.
That is a completely different agreement for €100 million facility that on Mr. Sandilla's evidence didn't go through. So this is a guarantee in relation to a completely different loan entered into between Mr. Juma and a party that is not a claimant. Can we look now, please, at the corporate guarantee, which is on your D11, and the page is just loading for me. Sorry. 225.
Yeah.
And this concerns whether or not Arj, as second defendant, is properly joined to this action. And we see there it is a guarantee to EFG Bank AG, not EFG Bank Limited. If we look then at definition.
My bundle has been very slow.
Okay.
I haven't got it up yet. Yeah.
And if we look then at definition 1.1d,
yeah,
we see there
it's very
makes
small.
good.
1.1d means the group from time to time comprising the bank,
Exactly.
holding subsidiary companies and affiliates.
Exactly, which makes good the submission I made to you a moment ago, that Mr. Sandilla just refers to the bank as EFG, but it's AG, SA, Limited, different companies in the group. And this is a guarantee not to EFG Banking Group, but to the bank, EFG AG, as defined in the rubric at the top.
So AG can sue on this guarantee.
AG can sue on this guarantee,
and it can do so in relation to any obligations made to the bank as broadly defined, but limited can't. That's your point.
Well, yes, but wait also, because if we look at 1.1f, I just need to bring this to your attention. 1FI, guaranteed obligations means all monies, obligations, liabilities now or at any time hereafter owing incurred to the bank or any of the bank's branches or offices or any part of the world by the borrower. That begs the question of whether whether EFG, I accept whether EFG Bank Limited can sue. In our submission, that is not the case, because if it meant that any bank in the EFG Bank group, it would have said so. So these are branches of EFG Bank AG, which, from looking at the various jurisdiction clauses, obviously operates in a series of different Swiss, I think in a series of different Swiss jurisdictions, or perhaps other jurisdictions, not clear. But what certainly is the case is the guaranteed obligations are to the bank, the AG company, and various of its branches, and not the banking group. So those are points as to why there's no good arguable case by the second claimant against the second respondent under the corporate guarantee and the third respondent under the personal guarantee. And as I say, I accept that those are not matters, I don't think, given the ruling you made at the last hearing, on which I can rely as matters which Ms. Bijlani was in breach of her duty of full and frank disclosure to bring your attention to at the last hearing, but they are nonetheless important matters as to whether the order should be discharged, because there is not a good arguable case, if I can make that distinction.
Yeah, okay. All right.
The other things that have arisen since the skeletons came in is that my learned friend now seeks to rely on evidence from a Swiss lawyer and from a Hong Kong lawyer. Those witness statements, I forget the dates of them, but I think they're dated 20th and the 21st of May, or perhaps a couple of days before the skeletons were due. I didn't make allegations in my schedule, or indeed in my skeleton argument, that these claims did not have the fact that my clients might argue that there was not a claim under the law of the documents being relied upon, i.e. not a claim at Swiss law or not a claim at Hong Kong law, because I didn't have a Hong Kong lawyer or a Swiss lawyer at my elbow to tell me those are arguable points. And it seemed to me that whilst there are some points which feature in some systems of law and not in others, a debt is an obligation that is owed in most jurisdictions, and so it wouldn't sound very good if I were asserting that, well, under Swiss law you wouldn't actually have it, you might not have a claim for this, and she should have said we might run that defence, because it didn't seem to me to be a particularly attractive point. The evidence has added a new complexion to it, though, vis-a-vis jurisdiction, and that is because what my learned friend's Swiss lawyer has said about the effect of asymmetric jurisdiction clauses.
Yeah.
Asymmetric jurisdiction clauses are a troubled feature of English law. Your Honour will have seen them a lot because there's arguments about Hague Convention and which member state can get exclusive jurisdiction, etc., etc. In a jurisdiction like the DIFC, they have obviously a rather different import, which involves just construing them and trying to ascertain what the parties actually intended in relation to jurisdiction.
So just which is the paragraph of Mr. or Dr. Vensal's evidence that you're referring to?
Just trying to find him in the bundle.
I mean, I've got him separately.
Sorry.
I mean, he sets out the terms of the clause at the top of page 5.
So if you just, I'm sorry, Your Honour, just give me a moment. I'm just going to find it in my emails. I'm sorry.
Well,
I think it's about paragraph 18 of his witness statement, where he sets out that essentially at Hong Kong law, I may have been referring to the Swiss guy, for which I apologise. At Hong Kong,
I've been looking at the Swiss,
that's my
Swiss man. Right, let me just find the Hong Kong.
Benashal, Ben Sahel. No, that's the Swiss guy.
So the Hong Kong evidence is from Marcus Gordon, and that's at 1943.
Thank you
very much. Yeah, I've got that.
Where paragraph 18, Your Honour, he sets out his interpretation of the Wisdom Top case and the way that this asymmetric jurisdiction clause would be construed at Hong Kong law which is, of course, the law of the corporate guarantee. And this does relate to my submission in relation to full and frank disclosure in relation to jurisdiction, because in circumstances where I'm a learned friend seeking to rely upon an agreement governed by Hong Kong law, who should have investigated whether or not under this agreement, in fact, that asymmetric jurisdiction clause applied in the way that she asserts. And the answer is that it on her own quasi-expert evidence is that it doesn't, and that the test that the Hong Kong court would apply is not dissimilar to the forum non-conveniens spiliada English law test.
And just to be clear about that, you get that from what Mr. Gordon says at the end of paragraph 17.
And
on the other hand, if the bank wishes to sue, it may bring claims not, but also overseas. Well, if the bank chooses to bring claims overseas, it would still have to justify why the claim should be brought there, as one of the subclauses conclusively demonstrates that Hong Kong is the most appropriate forum. So what you're saying is that the bank, what he is saying is the bank can bring overseas, but as a matter of Hong Kong law, he's still got to justify why it's appropriate to bring it there.
Yeah, exactly. Exactly. And if that theme is continued at paragraph 18, where he says that case is applicable to this one, and he continues accordingly, the effect of 18.2.
Yeah, so that's really just justifying what he said. It's the same point again.
Yeah, sure. But it's putting it beyond doubt that that's what he means. Yeah. And so what we know,
I've got a point. So you're saying that this demonstrates that in relation to in relation to this document, one ought to be considering whether there is a proper basis for the claim to be brought in Dubai by reference effectively to a forum convenience point.
Exactly, effectively to the forum convenience point by reason of the contract between the parties.
Yeah, no, I get it.
Yeah, that's the first thing to say.
Okay.
And it's of relevance because of another matter that my learned friend raised in her skeleton. According to her skeleton, she relies on the jurisdiction point on Article 14b of what I call the new, I think we're all calling the new law, which is in your bundle at J2, law number 2 of 2025.
Sorry, again, please, if you've got them, give me the.
Sorry, yeah. It's just loading for me. I can't give it to you just yet. 1070 is the beginning of the document, and Article 14 is on 1077.
Yeah.
And Article 14b is 1078. The DIFC courts have jurisdiction to hear and determine civil and commercial claims and applications where the parties expressly agree in writing to the DIFC court's jurisdiction, whether before or after the dispute arises. And that is referred to generally by DIFC lawyers as the opt-in provision.
Yeah. Yeah.
This is the first time she's ever said it. It wasn't in.
All right. Now time is moving on.
Yeah.
What you've done thus far is expand well, in essence, the points which were made in relation to lack of full and frank disclosure, and in the way that you've explained on good arguable case, which well certainly comes in the question as to whether or not there should be a reimposition of the injunction.
Yeah. Exactly.
Okay.
In terms of what else I have to say on, obviously I wanted to address you in relation to full and frank disclosure in relation to the real risk of dissipation. I put some of that in my skeleton. I don't want to.
I keep on getting. Yeah, sorry, go on.
I don't want to annoy the court by going over what I've already put in my skeleton. But I think you were about to say something, Ron.
No, it was in relation to something. Someone keeps on seeming to join, but that's all right. And sorry, just to be clear on where you are referring to that in your skeleton, you're referring to the risk of dissipation in relation to what is said. Sorry, I'm just looking at your skeleton. It's at
risk of dissipation is at page 13 of the skeleton.
Thank you. Let me just have a quick look at that. Yeah, I mean, I've got your points down to paragraph 64.
Yeah.
And they are then bolstered by the point which you make in paragraph 65 to 67, which is effectively, this has been going on for ages, what's changed?
Yeah, exactly. And I suppose, I mean, I know your Honour has it in the back of his mind already, but all the points I make here are essentially very obvious things that my client would have said if represented, and it was a breach not to bring those to your attention, or to mention that we would have argued them had we been represented at that first hearing before you, a fortiori in circumstances where my learned friend positively asserted that there was no defence to the claim and nothing else that needed to be brought to your attention.
Yeah, okay. Yeah.
On the Les Ambassadeur point, I've asked you to look at paragraph 16 and 19. I wonder if Your Honour hasn't, we might look at those.
That's at 1560.
I'm sorry, paragraph 16 and 19 of Les Ambassadeur that I deal with.
Yeah, it's a page 1560.
1560, it is. And might I just ask Your Honour also to look at paragraph 14. I mean, you may consider this is pretty obvious, but I'm not just saying I don't need to read all of that, but if you've got it turned up.
So starting at page 1559.
Correct.
Yeah, so that's making the point that it's not security.
Yeah. I've been talking for an hour now, so I think if we was, I think Your Honour said you were hoping to rise at the short adjournment, which I think you said would be at 1 Gulf time.
Yeah.
Which would be.
Yeah. Your
Am I running out of time?
You didn't. Well, I had a bit of an introduction and so forth, but yes, you're running it short on time. So
okay.
Sorry, I've read paragraph 14, which illustrates the point which you're making before. And sorry, it's paragraph 19.
14, 16, and 19 in the paragraphs I've just asked you to look at.
Sorry, 14, 16,
and 19.
Yeah. Okay, I've read those.
And if I address you on jurisdiction in about 90 seconds.
Yeah.
It's
well. The point which I want to hear you on.
Yeah.
In relation to jurisdiction in particular,
yes.
is what is said in a nutshell by you about the fact that it's too late to challenge it, given the acknowledgement and service and so forth.
Yeah. That I think is an extremely unattractive point from a learned friend to run. For the reasons I've set out, it is not particularly clear how this claim form was served. The DIFC is a court without a territorial jurisdiction. And in the sense of, in English courts, there's lots of arguments about service out of the claim form, which just don't occur here. Your Honour will know from the rules that if you want to serve a DIFC claim form, you do it in accordance with the local rules of service.
Yeah.
There's no explanation of what the local rules of service in Cayman or was we on about to say something?
Well, no, I mean the point that the point which you've described as unattractive is, I mean, by whatever means, in this case, service was acknowledged.
Yes.
And the rules state that within 14 days of the acknowledgement, I mean, summarising, if you're going to take a jurisdiction point, you take a jurisdiction point.
Yeah.
And you were outside that time, albeit relatively narrowly. And the question I've got is how do you then deal with the fact that the jurisdiction points which you're taking, and let's assume for present purposes that I'm with you that those points are at the very least well arguable, are still open to you in the light of that? That's the question I want you to address.
Yeah, I suppose the answer to that is, to the extent I need the court's discretion, I ask for it. And the reason I ask for it is because if you look at the particulars of claim, they are dated the 28th of March. And so the notion that I should, within 14 days of the 9th of March, have been able to properly mount a jurisdiction challenge when the case had at that date not been properly pleaded or set out is not fair. And the English courts and other common law jurisdictions are routinely faced with cases where, prior to a submission to the jurisdiction, because the rules clearly state that an acknowledgement of service is not a submission to the jurisdiction, and in circumstances where my client has, every time he's come before the court, said I dispute jurisdiction, and then in circumstances
just in relation to that, you refer in particular to Mr. Jimmer's, I can't remember which, but it's the one which you refer to in your skeleton.
That's the one that, sorry.
Which just says he's going to dispute jurisdiction, but effectively says that he's going to do so in the future. That's the point. So, yeah, go on.
Well, that is what when the claimants acknowledge that. I think we probably put it differently, but so I don't want to be tendentious by saying that jurisdiction is raised, but they acknowledge the manner and the way you've just expressed it. In Mr. Whitehead's witness statement, in response to Ms. Bijlani's application for default judgment, the date is actually put earlier in Jumma 1 at the 28th of March. But what stepping back, what I think it is fair to say is that this defendant has always been saying, I'm going to dispute jurisdiction in this case, and it would be
what you say is this. First of all, the way in which the claimant actually asserts its claim isn't clear until the particulars of claim. Secondly, Mr. Jimmer has always been saying he's going to dispute jurisdiction. Thirdly, that therefore the failure to file an application within 14 days is a pretty obvious oversight, and I ought to allow the point to be made notwithstanding that. That's the summary of your argument in relation to this.
That's the summary. Adding, it would obviously be completely unfair and an extraordinary windfall for this jurisdiction point essentially just to go in the
I mean, I understand. And is there any help that one gets either from the rules or cases in relation to the approach to a challenge to jurisdiction in these sort of circumstances?
Yes, there is. I think it's fair to say that the question of whether or not relief from sanctions should be given in this sort of circumstance is tied up with the merits more generally. And so, for example, there is a case which I'll try and remember the name of, where the judge says, I've looked at this jurisdiction challenge and I've been asked, and it's come late, but it's not a good jurisdiction challenge. And because it's not a good jurisdiction challenge, there's no way I'm going to give relief from sanctions. In other words, the question of whether or not you give relief from sanctions is itself tied in to
if that case is not before me, I infer from what you said it isn't. I wouldn't mind knowing where that case is going. But that's what you say in summary in relation to that point.
I accept there are other cases where judges have said, these are the rules, you didn't comply with them, there's no good reason why haven't you stuck out. I accept that. But the reason why this is important is because the relief from sanctions jurisdiction is a discretionary jurisdiction. And so the fact that there is another case in which relief from sanctions wasn't allowed is not an authoritative reason as to why you shouldn't.
No, I understand the general point. I think it would be helpful just to have a look at that. All right. Well, that maybe that Ms. Pagilani will come back in relation to that, and if so, we'll hear what she has to say in relation, and you can respond if appropriate. Right. That's as far as I'm concerned. I've got the points that you're making as to the substance of the jurisdiction from your skeleton, and I understand what you're saying about it's too late. Anything else that you want to address me on in relation to what I'll call the first series of arguments?
So not including contempt.
Not including contempt.
Yeah. Well, I think if you're, I think I've had my time. I think, and so I think I'm probably best. So I have some time to reply at least.
Yes. All right. Very good. Now it's 11:05. I think we will take a short break at some point during the morning. It would ordinarily be a little bit later than now, but Ms. Pagilani, do you want to make a start and then have a break in 10 or 15 minutes, probably for no more than 10 minutes? Or would you like to take the break a little early and then make your submissions?
I'm happy to make a start and have a break and say 15 minutes, as you stressed.
Yeah. Yes.
Thank you.
Okay.
If I could ask you to look at the order on page 49 of the bundle.
Yes.
So this is following the issuance of the freezing injunction. We had a hearing, and you will recall that there was a request by respondents that they be given an extraordinarily long amount of time to file an application to vary or discharge the freezing order. And you clearly said in your order at paragraph 2 that
sorry, this is my order. So just dated. Which date is it?
It's actually dated the 20th of March, but it was issued on the 28th of March.
Yeah.
And you clearly required the respondents to make an application seeking to vary or discharge or set aside the freezing order by 5 p.m. on the 24th of March.
Sorry, why are we looking? What point is you're making by reference to this order? What's the submission?
I'm going to make a point that the way that the respondents have conducted themselves in relation to the application to vary or discharge the order is not permitted by reference to the case law that I will take you to. And I'm going to make the point that the application that is before you has not been amended in the way that you clearly suggested it needed to be at the last hearing. And I can take you to that application.
Sorry, just to be, so the point you're making is what? That the respects in which the respects in which the respondents say that the order was obtained by an absence of full and frank disclosure can't properly be taken today. Is that the point you're making?
Effectively, yes, I'm saying that. And I appreciate the ambush that's happened at the last hearing, where lots of new points are being raised without notice. And I appreciate that the matter was adjourned. But the fact is that you directed an application be made by the 24th of March. An application was made late it was actually made on the 4th of April for discharge. That application doesn't particularise at all any of the grounds for failure as alleged of giving full and frank disclosure. We've had multiple affidavits from Mr. Jummer which say absolutely nothing. The applicants are then ambushed at the last hearing with points which I say are absolutely hopeless points. Many points are made that have no credibility and have been dropped by my learned friends today, it seems. And it's simply not permissible by reference to the case law I will take you to. If I can ask you to have a look at page 31 of the bundle, which is their application to discharge.
We'll just sorry. I'm before we get to this. Your submission today is that despite the adjournment last week, despite the provision of particulars, it's not open to my learned to the respondents to assert, for example, that the failure to deal with the absence of a business exception to the form of the Moreva injunction, that point, even if it's otherwise a good one, and even if you were guilty of a failure to bring that to the attention of the court, you're saying that's not open to me to consider today. That's what you're saying.
And that's what I've put in my skeleton argument.
Yeah, okay, I'm simply seeking to identify what submission we're on at the moment. All right.
Yes. So if I could ask you to look at page 31 of the bundle, which is the respondent's application for the discharge of the freezing order. And then if you turn to page 32, you have a statement that the reasons given for the discharge are as set out in the 5th affidavit of Mr. Jummer.
Yeah.
And in the 5th affidavit of Mr. Jummer, which starts on page 602, there is no articulation at all of any basis for failure to give full and frank disclosure.
No,
all
it's all this stuff about how there was no section dealing with full and frank disclosure and all of that material. I've got that point, and I've also got the point that the detailed articulation of the case, which is now being put, really began with Mr. Fairseagle's oral submissions on whatever date it was, which led to the adjournment till today. I've got that as the factual point.
Yes, and I say that the respondents have had plenty of time to make these arguments. They've waited weeks and weeks after your order was made. They've wasted court time. They've wasted legal costs in firing off at the last hearing points that were not articulated in any shape or form in the application, in the 55-page skeleton argument, which I spent my weekend reviewing. And then they pop up at the hearing and start advancing a load of nonsensical arguments. And by reference to the law, that should not happen.
All
and
right.
If I can
you've got 2 points. One is that they're nonsensical arguments, and you'll have to address me in relation to that. But the second is that even if they're good points, then I shouldn't hear them, even though you've been granted an adjournment to deal with them. So that's the burden of the point you're on at the moment. That second point.
Yes, that's correct.
Yeah. All right.
If I think you mentioned at the last hearing that there had been decisions by Jacobs J, which have been referenced in the skeleton arguments. You'll be familiar with the Union Fenosa case, but if I can take you to the second case I reference, which is the public institution case, and if you could go to page 2241 of the bundle. Paragraph 139. This is a point that will come out in relation to
page 2241. Which case are we in? Sorry.
This is the Public Institution for Social Security against Mr. Kamran and Muzega.
Yeah.
And paragraph 39 of the quote from the Rolls-Royce case is a point that is actually relevant to the arguable case, but to avoid going back and forth with the authorities, you'll see it says that an applicant does not have a duty to disclose points against him which have not been raised by the other side, and in respect of which there is no reason to anticipate that the other side would raise the points. And as I said, I'll come back to that on the arguable case submission. And then further down, paragraph 142, G on commercial injunctions, the quote starting at the top of page 2242. A party seeking to have without notice relief discharge for non-disclosure must give adequate notice that this ground is relied upon together with sufficient particulars enabling the other party to understand the case to be advanced. An allegation of non-disclosure is potentially serious both for the other party and his legal advisors, and the party complaining of non-disclosure must give sufficient notice of his complaint so that there can be a fair hearing, and it should be made without unnecessary delay. And I emphasize unnecessary delay, because there has been an incredible amount of delay here.
Well, all right. Let's assume in your favour that these points could and should have been made when the application to set aside was put forward, and let's assume also that the reason why they weren't made is because they come about as a result of Mr. Pierce-Eagle having looked properly at the matter, etc. But let's assume also that, I mean, obviously if the points are nonsensical, then they don't go anywhere. But let's assume they're otherwise good points. What that means is that good points have been taken late, and that the order, a draconian order, was obtained in breach of the obligations of full and frank disclosure. Why do you say that if that is the factual position in relation to an order which was first made on, right, just getting my dates correct, but in relation to an order which was made on the 10th of March,
yes,
and where we're now on the 23rd of May, and where they were made, I think, probably some 3 weeks later than they should have been on yours, nonetheless, the court shouldn't consider the position.
I say it shouldn't consider the position. When you look at the factual situation that we're dealing with, you're dealing with respondents who completely ignore your orders, Your Honour. They've completely ignored the freezing order and the provisions that it sets out. They've completely ignored your 20th of March order. The respondents are represented by a law firm in Dubai who should know what the law is under their code of conduct in the DIFC. They should have advanced and set out clearly what the allegations were. Mr. Jumma even goes as far as saying on his solicitor's advice that he is not obliged to give his version of events in his affidavit. And that is just remarkable when you consider the law and what it says about the need to particularize what your arguments are.
Right.
You know, they just completely disregard your orders and act in absolute disrespect to the court in my submissions. And that kind of behaviour should never be allowed. It's just not acceptable.
All right. Okay. So your first submission is that because of the delays, and just to be clear, you accept that these points were brought to your attention on the 12th of May, and that there was then an adjournment to deal with those points until today. So your submission is that because of the delay in making the points until the 12th of May, when do you say they should have been put forward?
You made an order requiring an application for variation or discharge of the freezing order to be filed by the 24th of April, sorry, 24th of March, and you made it very clear to the lawyer who appeared on behalf of the respondents that he was not going to get the 4 weeks that he was asking for, and that he needed to act promptly within a couple of days to vary or discharge the order.
Right. So your point is that the delay is between the 24th of March and the 12th of May. So that is, by my calculations, 5 weeks, I think, 6 weeks. I think it's a 7-week delay. Is that right?
Yes, I think that's about right. Yes.
All right. And from a practical proposition, yes, all right, okay. So because of the 7-week delay between that period, I shouldn't entertain the submission as I shouldn't entertain the substance of the application.
Yes, I that's the point I take. In circumstances where lawyers should know what they need to do when making such a serious allegation of a failure to give full and frank disclosure, they've instructed their own client to swear an affidavit that says, I'm advised I don't need to tell the court or the other side what my allegations are,
Okay.
or even
right.
what my defence to the claim is. I mean, it's a sworn affidavit to that effect.
Yeah, okay. All right, well, I've got that point, and as you say, so your skeleton argument, let me just call that up. Your skeleton argument deals with this.
So
your skeleton argument really deals with this at paragraphs 28 or 26.
28, yes.
Through until
32.
32, and that's the point that you make, and as I say, the point you're making is they should have been made by the application should have been made by the 24th of March. Okay,
that's right, and I just emphasise, the commentary that it needs to be made without unnecessary delay.
Yeah, all right. Well, I've got that point now. Let's move on to the substance. I mean, we've got what was said, and it's fair to say that I did raise with you what I think it's fair to say did seem to me surprising, which was the absence of express consideration of full and frank disclosure either in the witness statement or the skeleton argument. But the first specific point which is taken by the respondents now is the form of the order. And I said, well, is it in the standard form? And you said it was. Now, do you accept that obviously carries with it the duty to draw attention to any particular point? So in relation to, for example, the ordinary use of business, where you had got an obvious possibility of the defendant, at the very least, arguing that there should be a terms of business exception, that should have been brought to my attention.
Your Honour, I think the situation is that the form of order in the RDC rules as we've heard from my learned friend, has brackets around certain provisions, and it provides in the rules that the model may be modified as appropriate in any particular case. And while I agree that it was said before you that it's in standard form, the position taken by the applicants was that where things are in brackets, and given that the rules specifically say at RDC 25.34 that you can amend the sections in brackets to suit the case. And
Well, all right,
there is case authority.
Let's just look at that. The context in which this is being done, you accept, isn't it, is that it was your duty to bring to my attention, on a full and frank basis, points which a defendant would be likely to make in relation to the extraordinary relief which is being sought against him. You presumably do accept that?
I do accept that, yes.
I mean, isn't it obvious that in the context of an order about where you're taking out points in brackets, which has got a terms of business exception, Mr. Juma would have been likely to make that point if it had been, if Mr. Juma had been there?
I don't agree that he would, actually, because the freezing order itself states very clearly on page 43 of the bundle at paragraph 12 that the respondents may agree with the applicant's legal representatives that the above spending limit should be increased, or that this order should be varied by agreement.
That can't possibly be an answer to that. That's a standard form.
Yes,
but the question is, surely you must have realised that Mr. Juma, or not you must have realised, it would have been obvious that Mr. Juma would have been saying, look, there's got to be a terms of business exception. I'm a businessman.
The evidence doesn't support that position at all. Weeks and weeks and weeks after the order is made, this point is thrown in to the mix by my learned friend. If Mr. Juma really needed this business exception, he would have come before the court far, far, far sooner. He's had lawyers acting for him for weeks who have responded late in contempt of court of the freezing order with an affidavit that says all of the assets of the respondents are encumbered. If he had any beef with the order, he would have come to the court far sooner. If all his assets are encumbered, what is it he wants to spend exactly? It just doesn't sit well with the facts, Your Honour. And in the face of respondents who are clearly guilty of fraud or capable of fraud, why would the court be putting in a business exception in an order such as this? And I've given case authority, Your Honour, DIFC case authority, which my learned friend failed and misled you on in terms of not bringing it to your attention at the last hearing. There's clear case authority before the DIFC courts. If I can just take you to that, please. It's at page 2288. And this is the case of SBM Bank, Mauritius, where it is at 2287. And the very same allegation was made in this case, the very same one. And yet my learned friend didn't think it appropriate to bring it to your attention, either at the last hearing during his ambush, or in the skeleton argument that he filed on Wednesday, or in his submissions. He's not said a word about it, not an utterance about this case.
Just calm down. We're into parties now. You're bringing this to the attention of the court. And what is it that you're relying on in this decision?
So this decision, if we look at page 2289, paragraph 13 is dealing with the business exception. And then further down the page before paragraph 16, it says, was the business exception optional? And then if we move down to 2290 and paragraph 27 in the context of
just give me 2 seconds. Right. So this was an application to vary an order so as to include the business exemption. It wasn't an application. Now, on full and frank disclosure,
it's dealt with at paragraph 27, Your Honour, where the judge makes a finding that the business exception is optional. And in his view,
where's the allegation of full and frank disclosure?
The allegation is made in the application that has been filed to vary the injunction.
Forgive me, which paragraph are we looking at now?
We're looking at paragraph 27, Your Honour.
Sorry, that was me last time.
It's on page 2290.
I've got it, thank you.
And you'll see that the judge has made a finding that the business exception is optional. Its exclusion in the present matter was consistent with the claimant's case, and Prime's conduct after it had notice of the worldwide freezing order suggests that SBM was, at least at that time, correct in its conclusions, and it follows, in my view, that the question of material non-disclosure do not arise.
Well, I mean, look at what the judge says at 22. If an injuncted defendant conducts business, the business exemption will prima facie be appropriate.
Yes, I appreciate that there are circumstances where a business exception is appropriate.
But I mean, Mr. Juma was a businessman.
He's a businessman who is clearly presenting fraudulent documents to the bank, not only EFG Bank, but also Bank of Singapore, where the judgments confirm exactly the kind of individual we're dealing with.
I mean, just to be clear, your submission is that in this case, when asked by a judge whether it was in the standard form, and it's said yes, there was no need, either because of the inherent nature of the business exception or because of that specific question, to say, well, Your Honour, I should tell Your Honour that there is no business exception here. No doubt Mr. Juma would argue that there would be one. You're saying that that was not something which you were obliged to do. That's your submission.
I'm saying it was my understanding that, you know, it was clear that we were dealing with individuals and a shareholder of companies that was dishonest, and that's
not an answer to my question.
It was not.
That's not an answer to my. Are you saying, having reflected upon it fully, that this was not something which should have been brought to my attention?
I'm saying it didn't occur to me at the time, Your Honour, to bring it to your attention, because I had before me.
That's a different matter. That goes to the question of deliberate breach, and you're saying it didn't occur to you to consider that matter. Well, so be it. But the question I've asked you is this: do you accept that, in the light of Mr. Juma's status as a businessman And in the light of the status of the order, it is something which you ought to have said, well, the defendant will probably assert that there should be a business exception.
I accept that it would have been better to bring that point to your attention, that it had come out. But as I've explained, Your Honour, the thinking of the applicants and the team was that this is not an appropriate circumstance where you would include such a business exception, where accounts have been presented that as on the face of them have been audited by Ernst & Young, but clearly haven't. And
Right.
there's multiple other evidence of dishonesty, which is why, you know, it didn't occur to raise it.
Now, I mean, it's a fact that I raised with you at the original hearing, but it's a point which is made, and this is a point which is made in Mr. Juma's witness statement, admittedly without particulars, but that there is no express section, either in the skeleton argument or in the evidence obtaining the original freezing order, dealing with the duty of full and frank disclosure. Where do I get the fact that the claimant's legal representatives thought about the duty of full and frank disclosure and what was necessary to be given to the court? Where do I get that in the evidence?
Well, there's not a particular heading in my skeleton argument dealing with it, but I was asked the question, as I recall, at the hearing by you. Yes, and the point that came to mind was making sure that you understood the points that were being advanced in relation to good arguable case and risk of dissipation of assets. And we then spent some time looking at the scope report, which was put before you, showing the nature of Mr. Juma's business interests across many different companies.
All right.
And so I think there was certainly a moment taken when the issue was considered, but certainly when the application was filed.
Sorry, go on.
When the application was filed, of course, careful consideration was given to full and frank disclosure and making sure that the court was aware of all material facts. And, you know, for example, if I knew of a defence Mr. Juma had raised in relation to this claim, it would have been raised before you. Okay. But what's happened, I think, it is with the business exception, it was taken out of square brackets because it was considered to be optional.
All right. It's just past 25 to. I think what we'll do is we'll take a break now for 10 minutes, and then we'll carry on with your submissions, Ms. Vigilani.
Thank you.
I'm just going to turn off my. Oh, sorry, I see my camera's gone off. I didn't intend it to go off.
It didn't go off very long ago, Your Honour.
I must have clicked it. Right. Anyway, we'll. Yes, Ms. Vigilani, are you ready to continue?
Yes, Your Honour. I think we've concluded my submissions on the business exception.
Yes. Well, and I think also the other changes to the standard form order, haven't we? The guarantee and the specific assets, or not?
Well, no, because in relation to the guarantee, as is quite often the case, an applicant can try and put forward credible financial accounts, which the court can consider and decide whether that is good to substantiate the cross-undertaking and damages. And quite often the case that the court will decide that there's no fortification required.
Well, no, I mean, I accept that. I mean, let's the question on this though is whether or not it was whether or not the applicant should have said, look, we should tell you there's no fortification required. There's no fortification being put forward, and the reason for that is that, I mean, I think what you'd say is that the applicants are plainly good for any money without the need for fortification. That's what you'd have said.
That's what I believe I did say, Your Honour, in my skeleton argument for the freezing order. Although I'm not sure where the reference for that
well,
is.
let's just have a look at that. Let's just see that.
I certainly would have said, you know, exhibited or referred to the evidence of Mr. Sandilla and the exhibits being the financial accounts to explain why the applicants were good for the money. I think it may be on 947.
Two to 87, I think.
So maybe a better thing to look at is the affidavit of Mr.
Just for a second. So 2287, the applicants have provided a cross undertaking damages in circumstances leading to grant of railway. So that says there's a cross undertaking, but it doesn't say anything about fortification.
No, but the fortification is at the discretion of the court, and
of course.
You know,
the question is whether or not you should have said, look, there's no fortification here because the you know, the claimants are good for the money. I mean, essentially.
Well, yes, and certainly I have to say in other cases that I've dealt with, accounts are submitted and looked at, and the court then decides whether that's good enough on the basis that it's always open for the respondents to apply and seek fortification if they consider that the accounts are not good enough.
Right. So that's what you say about fortification. Sorry, was that I don't think there's any express consideration of fortification in the material before you, and I certainly can't see it at page 2287. But if there is consideration of that, can you tell me where it is?
Sorry, sorry, Your Honour, just to clarify, you're asking me where?
Well, I thought you were saying that in your skeleton argument, you'd expressly considered the question of fortification, but I don't think that's correct. I think what you're saying is that you dealt with the existence of a cross undertaking, which of course was there.
Yes, yes.
But there's no, as far as I'm aware, there was nothing which was put before me which discussed the question or considered the question of fortification, i.e. the guarantee.
No, but the accounts were put before you, which, as I've mentioned, is often where you've got a very credible applicant.
Yes, no, I understand your point, that had the point being put forward, you'd have said, look, obviously we don't need it, or you know, they may suggest there's a need for it, there obviously isn't, or something like that. But I'm on an anterior point, which is there was nothing put before me about consideration of cross undertaking. I think you agree about that.
Yes.
Okay.
And then the last point, which my learned friend has not mentioned today in relation to paragraph 7, an applicant would only be able to identify specific assets that it knows about. So, you know, for example, if I'm arresting an aircraft in Dubai, I would name the aircraft in the order, or if I'm freezing a bank account or a property, I would name it. But in circumstances where we just do not know the current asset situation of the applicant, it's not possible to do that.
Yeah.
If I can then, I think, deal with this point that my learned friend has made about financial error, as it's been described. In the earlier affidavits of Mr. Sandilla and the particulars of claim, at 2594 is a section from the 6th affidavit of Mr. Sandilla. And you'll see that he is now correcting what seems to have gone wrong with this typographical error. And
so this is just to be clear, this is the 6th affidavit. This was the one which is sworn. Just what date was it?
this sworn on the 21st of May.
Yeah.
And on page 2594, you've got his explanation of the typographical error, as he puts it, in relation to the figures. And he explains at paragraph 11 that there's an error in the principal loan amount stated at paragraph 28 of his 2nd affidavit. And there he gives the correct figure.
Yeah. Now, the point which is taken against you, I mean, I think it's accepted. There's obviously a 2 million error there, but you can't tell from this on affidavit. All you can tell is that sums don't add up, and there's an error somewhere. You don't know what the error is. You presumably accept that.
Yes, but I'd also take the point that the error, there's been no error in the statement of the amounts due.
Well, okay, then I understand that. And the second then point is neither this affidavit nor the correction nor the particulars of a claim explain how you go from the positive balance which you get of 6.5 odd, sorry, 6.5 odd million pounds to the negative value of 4 million euros. In other words, we don't have any identification of how you get from a swing of what must be almost 10 million pounds.
There hasn't been put, I accept there hasn't been put before the court statements detailing all these figures. It's quite, as you'd appreciate, quite a complicated arrangement where Mr. Jum has been lent various money, has liquidated various assets. We've got different currencies across the different accounts, but I would submit that the amount of the claim is not incorrect and has never been stated to be incorrect. And if the respondents didn't understand the amount of the claim, as you referenced earlier, they could have made a request for further information or better particulars.
Okay. All right.
If I can then deal with the point that my learned friend makes about the different companies, as he put it,
Yeah.
In relation to the framework agreements, the guarantees. You'll recall he's made a submission that different entities are party to the different agreements. EFG Bank AG, EFG Bank SA, EFG Bank Limited. I have to say it's quite refreshing to find someone who's got worse language skills than I have, but my learned friend should appreciate that EFG Bank Limited in French is EFG Bank SA. If I can take you to 2617.
Well, hang on a second. Are you saying that EFG Bank Limited and EFG Bank SA are the same legal entity?
That's correct.
Right. So where do I get that from?
At 2617 at the top of the page, you see the registered name EFG Bank AG.
Hang on. 2617.
Do I have a tab number?
I think it is
Right. So this is the
L,
identity of the claimants.
within L.
Sorry, I'm not quite there. Is
It's in tab L at the bottom, 41.
41, thank you.
Okay. So this is from the Zurich, the Swiss Cantonal Registry for Zurich, and this is presumably for the Swiss company, which I assume is AG. Yes?
Yes.
Okay, let me just. So
forgive me, when was this added to the, when was this added to the bundle?
Mr. Fearseagle,
Sorry.
let me just 2617 Swiss registered AG. All right. Sorry, if you and this obviously isn't a party to the claim.
Well, I think what my learned friend was saying in relation to the documents that he took you to, that the that different entities are party to the
No. So my question is a much more simple one. This registered company, EFG Bank, AG, is
Yes.
not a party to the claim. Is that right?
It is party to the claim because EFG Bank AG is also known as EFG Bank Limited. They are all the same entity.
Right. So you're
my
saying
instructions.
that well, I do want to be completely clear about this because it's not my experience that for banking companies and so forth, you call a company which is registered in Switzerland and is known as EFG Bank AG when it's in England as EFG Bank Limited, and when it's in France, it's known as EFG Bank SA.
It's the English, French, and German equivalent. So in English, it's EFG Bank Limited. In French, it's EFG Bank SA, and in German, it's EFG Bank AG.
Well, for what it's worth, SA stands for Société Anonyme, which is not a translation of limited. I'm not sure what AG is German, but I don't think it's a translation of limited. And my usual expectation would be that you call companies by the names of where they're registered. Now I see here that you've got registered name EFG Bank SE with underneath it EFG Bank SA and EFG Bank Limited. And I see that in this document in German, there's the purpose of the company, etc. But are you saying there is no legal entity which is separate from EFG Bank AG, known as EFG Bank SA or EFG Bank Limited?
My instructions from my clients are that EFG Bank AG, EFG Bank SA, EFG Bank Limited are all the same entity. I have a Mr. Sandilla on this here at this hearing who can answer the question probably even better than I can if the point needs to be taken any further. But those are my instructions, and I'm told that is how they operate as a bank. They interchangeably use these names for the different entities. So it's for the same entity, just depending on what is being done and where the money's coming from.
Right. Well, look, I mean, one could look at company searches. There certainly seem to be English registered companies registered at Companies House, which have English company names. But anyway, and are registered in England. But you're telling me, are you, that there is no English registered entity called EFG?
That's my understanding and my instructions, Your Honour. I can't say I've gone and checked it because I've been told that they're all that it's one entity.
All right.
But
Okay.
I'm happy to put in further evidence on the point.
I mean, I confess I find it surprising, but there we are. That's what you're telling me.
That's what I've been told, Your Honour. And further evidence can be put in on the point if need be.
It's not. All right. So.
And then.
Go on.
Sorry, apologies. I was then going to deal with the credit agreements point that is taken. If we could look at that document, which is on 151 of the bundle.
Yeah.
My learned friend says that this credit agreement was not put into effect, so to speak, because Mr. Sandilla says in one of his statements that the money was never banked. This credit agreement is ancillary to the framework agreement that was entered into. And the reason why Mr. Sandilla says what he says about it is because when it was entered into on the 7th of April 2022, no money went out at that point because discussions were still ongoing with Mr. Jummer and his representatives. And further information over the months was given to EFG and Mr. Sandilla in particular, as is set out in Mr. Sandilla's evidence in the first and second of his affidavits. You'll see in the conditions precedent in the credit agreements that various documents had to be entered into and which were entered into, including the personal guarantee of Mr. Jummer, which refers back to this credit agreement. But as I mentioned earlier, it's ancillary to the framework agreement.
And sorry, where's the framework agreement?
The framework agreement is at 93 of the bundle, page 93 of the bundle.
Yeah. Yeah.
Various amendments, as you will have seen, were made, to the framework agreement, simply because there were, ongoing discussions with Mr. Jummer about what collateral he could provide. Lots of waiting for coupons, which never materialised in the way expected to be issued. And so when this credit agreement I'd taken you to at page 151 was signed, yes, it's correct that that credit agreement wasn't acted on in 2022, but that is because there were discussions ongoing. But that doesn't impact, I would say, the enforceability and the effect of the personal guarantee and the guaranteed obligations under it.
And what do you so how do you trace through, do you say, the claim of either of the claimants?
The first claimant, the DIFC branch or entity of EFG, has a claim under the DIFC agreement, which is at D1, starting at page 69.
So which that's page 69 of the bundle.
Yes, that's correct. And in that contract are undertaking. So if you look at page 76 of the bundle, for example, you've got clause 5 dealing with representations, warranties, and undertakings. And part of the claim advanced by the first applicant is that there has been a breach of those representations, warranties, and undertakings.
Now let's just have a look and see how that's pleaded. So if one goes to the particulars of claim, you plead the 5.1.3 at 2.6.
Yes, I think the next relevant bit on this point is at page 21, paragraph 13.
Yeah, okay.
And then the claims of the second applicant.
And sorry, just to why is EFG Middle East
EFG Middle East
suffered loss in relation to that?
Because of the way the accounting works. So EFG DIFC is arranging and facilitating the loans, and in the circumstances of a default, I am instructed that there is then a loss that is accounted in the accounts of the DIFC entity.
And where do we see that pleaded?
I don't believe it's specifically pleaded in terms of the loss position. But what is pleaded is that there's a damages case for breach of reps and warranties, which of course couldn't fly if there was no loss.
Well, I agree, but I'm just trying to understand this at the moment. I mean, EFG Middle East doesn't itself loan any of this money, does it?
No, it facilitates it, and it goes to lots of time and expense in terms of, its staff and members and its CFO.
Right. Well, so arranging. So that could lead to potentially a claim, but it's not going to be the amount of loans which are made by other entities within the EFG group, is it?
There is a point about the second applicant having the right to bring a claim under the DIFC agreement. It's not pleaded, I accept that, but we're dealing with points that are trying to be taken to dissect the contracts and what has been put before the court. But there is a credible claim, if necessary. The particulars can be amended, but there is a credible claim that the second applicant has a cause of action under the DIFC agreement. It's not party expressly to the DIFC agreement, but clause 3.19 at page 74 of the DIFC agreement does make it clear that, so this is 3.19, no person who is not a party to this agreement, with the exception of any relevant affiliate, can bring a third party claim under Part 10 of the DIFC law. I would submit that the second applicant is a relevant affiliate who would have a cause of action under the DIFC agreement. I should go back to my other point I was making about the first applicant. If my learned friend wants to start complicating things as to who's got rights, who hasn't, who's got causes of action, if necessary, I may want to amend the particulars of claim to bring a transferred loss argument. I mean, it's just what is necessary to recover this money when you're faced with all these arguments. But there is an arguable case here that the applicants, both of them indeed, have causes of action, both under the, so have causes of action under the DIFC agreement, and that the second applicant has causes of action under the framework agreement, the supplemental framework agreement, the personal guarantee, and the corporate guarantee.
All right. Okay. Now, can we just look at the second claimant and how it's pleaded them? The second claimant is the lending arm of EFG International. Well, EFG International, should we read, for these purposes, EFG Bank Limited as being EFG Bank AG?
Yes, I believe that's correct.
Just a second. I mean, we don't have in the particulars of claim, or I think in the evidence, an express identification, do we, of the company number? I mean, tell me if this is wrong, but the document you showed me from the cantonal register in Zurich, that will have a company number, but there isn't an identification of the second claimant, is it? I mean, it says the lending arm of the EF International registered office, but we don't have the number tying it down to the registry you showed me, do we?
I don't believe so, unless there's a number that's referenced
right, okay.
in any of
but
the finance agreements.
I mean, sorry. I mean, look, I do find it very strange that if the company main name is EFG AG, it should be referred to as EFG Limited. But there we are. That's we've discussed that. Okay, so we're now on to how EFG Limited has got a claim, and how's that?
So EFG Bank Limited, as second applicant, has a claim under the DIFC agreement for the reasons I mentioned. If necessary, particulars will be amended, but it also has a claim under the framework agreement, the supplemental framework agreement, the personal guarantee, and the corporate guarantee.
Right. And that's because it's a direct party to all of those agreements and can enforce those rights. Is that right?
Yes, that's the applicant's position. Yes.
And what do you say to the points made by Mr. Fierce-Siegel in his submissions earlier on this morning?
Well, in relation to the guarantee itself, the
Yes.
personal guarantee, I say that the personal guarantee of Mr. Jummer is referencing the credit agreement, and as I mentioned earlier, the credit agreement was ancillary to the framework agreement, was not actually put into effect when it was signed, because then further amendments come about. When the credit agreement was entered into, all of the guarantee documents, the pledge agreement, etc., were entered into because they're expressly referred to as condition precedents of the credit agreement. And as a result, Mr. Jum has given a personal guarantee in respect of the lending that's happened.
Okay. All right. And what you say about that is that, notwithstanding the points that are being put forward, there's a good arguable case for present purposes, albeit I think you're saying that in certain respects there might have to be amendments to the particulars. And you're also saying, as I understand it, that the potential difficulties in relation to this weren't such as should have been brought to the attention of the court in the context of full and frank disclosure.
Yes, that's right.
Okay. And
in the 50% test, which I've put in my skeleton, we're not required to have a mini trial, of course, about the substantive elements of the case. It just has to be an arguable case, good arguable case, as the test has been set down by the authorities.
Yeah.
This point wasn't raised earlier, but my learned friend says in his skeleton argument that the claim under the corporate guarantee is made at DIFC law. It's paragraph 45 of his skeleton. And then he says at paragraph 48, further, the claimants have pleaded their claim under the DIFC law. I don't understand those statements because that's not the case. The particulars of claim make it clear what the governing law is of the relevant agreements and guarantees. And there is indeed a paragraph in the particulars of claim explaining, Swiss law provisions, etc. So I don't follow that argument at all.
Okay,
I should also say that Hong Kong law is, of course, based on is Hong Kong's a common law jurisdiction, and the laws are very similar, if not identical, in many places to English law. We've had submissions made about service not being affected in accordance with the relevant governing laws, or jurisdictions rather, namely in the Cayman Islands and in Hong Kong. And at 980 of the bundle is a witness statement by Miss Lee, who's a Hong Kong lawyer, in which she confirms the valid service of the various documents, including the committal orders, etc., under Hong Kong law. And then at 991 is a statement by a Mr. Testori, who is a lawyer at Walker's, and he has confirmed that the document's been served in accordance with the laws in the Cayman Islands.
Okay, but for present purposes, you're saying that the relevant law were probably set out and so forth.
Yes, that's right.
Okay, all right. Now, let's just draw where we've got to at the moment. in relation to the alleged failures to give full and frank disclosure, you've made the points that you want to orally, is that right?
I believe so. I mean, obviously there are points about the existence of assets, and
well, I think the one thing I'd like to hear you on is the points about risk of dissipation, in particular, in the light of the points made by Mr. Fear-Seagull, and the fairly obvious point that, well, yeah, what's changed in relation to your client's knowledge, which leads them to bring the application in March of this year.
yes, and I think when we were in the hearing on the 10th of March, I believe that you asked me, you know, what has changed, or something along the lines of you know, why we're here asking for this freezing order now.
Yeah.
Watson Farley Williams were instructed, I think it was at the beginning of this year, and were given the papers. And as you'd expect, we, you know, were reviewing the financial accounts that had been provided by Dr. Khan in relation to Arj, and in relation to OCME, which is this company that was supposed to be subject to this bond issuance. And we looked at the documents, and we thought that the logo of EY on the financial accounts looked a bit strange, because it you know, for various reasons I probably don't need to go into. But we then wrote to EY and asked them if they had audited these accounts, and they came back and said no, they hadn't. And we then started to look at the other documents that had been provided by the client, and came to the view that, you know, we're dealing with seriously dishonest people here, and that there's an obvious risk of dissipation once Mr. Jimmer knows that we're coming after him for the money. And in the skeleton argument, I've set out, you know, the arguments as to why you must conclude that there's a risk of dissipation for other reasons as well. The Bank of Singapore case, which you were familiar with at the 10th of March hearing, follows quite a similar pattern to the case we're dealing with today, in the sense that Tom Montague Smith is advancing a position on behalf of the Bank of Singapore that bonds have been fraudulently misstated, and that is a key point that EFG take in terms of the OCME bonds and the Verde bonds, which were both put forward to EFG. I can take you to prospectus of OCME. I have to say, apologies to my learned friend, because they were added rather late yesterday. But the prospectus for OCME, which is this company that was issuing this bond as part of the security that was being offered to EFG off the back of the financial accounts, which were not audited by EY, but presented as being audited by EY. Alongside those accounts was the prospectus of OCME, and this is at 2710.
I'm afraid I don't think we've seen these documents. Could you tell me what tab number this is?
Wait a second. I'm not at all sure that I'm going to be very happy to have these documents if they came into the bundle yesterday. being adduced, but I want to just check with you. When did you become aware, or when did the claimant become aware of the fact that on its case, EY had not audited financial statements?
I'm just going to check the date that we actually wrote to EY. So at page 347 of the bundle is our letter to EY in Toronto, and I think we wrote to Toronto because I think that's where maybe the managing partner or someone suitable to deal with the question, rather than writing to the actual office that's purported to audit the account. We wrote to Toronto asking the question, did you audit these accounts, and can you check the authenticity and veracity of the documents? And then at page 430 of the bundle, you'll see I've chased EY on the 25th of February, and at the top of 430 is the response from a person named David saying,
Yeah, that's what I remember
yes,
seeing this. And what date was that?
that's dated the 26th of February.
All right. And in essence, in relation to the risk of dissipation, you say that these form the foundation of the second respondent's position.
Yes, and I also,
well, sorry, the first and second respondents. Is it?
Yes.
Just remind me of the relationship between the first and second respondents.
So the first respondent is the borrowing entity under the facilities, Arj Holding, and Arj Holding is the corporate guarantee, has issued the corporate guarantee, and that is the entity in Hong Kong. I should also mention that when the facilities were being, or the lending was being discussed, Dr. Khan, on behalf of Arj, who's the CFO, presented other documents, including management accounts of Marj and a personal net worth statement of Mr. Jummer.
Yeah, okay.
And,
Well,
you know, the figures are huge, eye-watering, in fact.
okay.
And
all right. Now, I understand enough about risk of dissipation, and that's the material change. And it's also the evidence of risk of dissipation, and it took place relatively shortly before the application, which took place on the 10th of March. That's what you say about that.
yes, that's right.
Right. Now, all right. We dealt then with, I think, or you dealt with the application to set aside the full and frank disclosure. You made the point that I shouldn't be considering it anyway. You've dealt with good arguable case. Now, suppose that I'm against you on the one or more aspects of full and frank disclosure. You say in your skeleton that I should nonetheless reimpose the injunction. Is there anything more you want to say about that?
Yes, so I deal with this at paragraph 77 of my skeleton. And of course, I could take you to the authority at 2282, which is the OJSC case.
Hang on. Sorry, paragraph which?
So page 2282, paragraph.
No, sorry. I'm just getting to your skeleton argument.
paragraph
77.
77.
Yeah, and the Christopher Clark decision is where in the bundle?
That is at 2282. Well, it starts, sorry, at.
Sorry, if you've got a tab number, I would be extremely grateful.
It's. I think it's tab J. I'm just trying to find the.
It's J, not L.
It's J, yes. I don't know the tab number, but it's
2282 is actually Jacobs, who's
it's in Union Ferosa.
quoting Christopher Clark.
Yes, sorry, that's right. So the Jacobs case is at Union Ferosa is at 2282, and in that case, and in another of the cases that are in my skeleton argument that Jacob J has been referenced, he quotes the OJSC decision, and the quote is at 2282.
Stronger the case the order sought, and the less serious or culpable the non-disclosure, the more likely it is the court may be persuaded to continue or regrant. So it's a balancing exercise, looking at how bad the original non-disclosure was and how strong the case is now for an order.
Yes, and I would submit. I think you asked the question of the respondents at the last hearing, in the sense that you said, "What is your beef?" And I'd go back to my earlier submissions, Your Honour, in relation to that very point, in the sense that weeks and weeks after the order's made, no application to amend or approach has been made to WFW to put in a business exception. If it was such an issue for the other side, they surely would have said something. But it also must be remembered that the respondents have categorically said all of their assets are encumbered. So what trading is going on? What business is going on? The second respondent is not a trading entity, as is stated in the evidence. And so I would certainly suggest that this is a prime example of a case. Were you to find that there wasn't full and frank disclosure, it's certainly a case that the order must stay, and the harm and injustice that would be caused if it didn't would be disproportionate.
Okay. Right. Okay.
I don't know if you want me to address you on jurisdiction, and
well, so far as these are separate comments in relation to jurisdiction, I mean the first point, which I expressly asked Mr. Fairseagle to deal with, was the point about the challenge was made too late, to which his response is, look, we've been saying we're going to challenge jurisdiction from the beginning, and in any event, it would be wrong not to allow us to do so in circumstances where, I think the way he would put it is, there are plainly better fora for the resolution of this dispute.
yes, and I say that the courts do apply strictly the rules and the deadlines in the rules. Incompetence of lawyers is not an excuse for not complying with the rules. They've filed this acknowledgement of service. There's no indication in the acknowledgement, which could have been given, that they intend to challenge jurisdiction. The rules are very clear in that it says you must, within 14 days of filing your acknowledgement, challenge jurisdiction. And the reason for the rule is so that we don't waste lots and lots of costs advancing a case and then finding we've got this jurisdiction challenge before us. Now, I've referenced in my skeleton argument authorities where a strict approach has been taken to the interpretation of deadlines. I also can take you to an authority at 1396.
Hang on, I just want to, I'm just looking, sorry, I'm just looking up the reference that you've given to Lehman and Lally.
Yes.
And which paragraph is this?
Paragraph 36, where the delay in that case was 26 days. And so I'm just putting.
Sorry, is there a tab number?
Sorry, I'm finding it difficult to navigate.
Sorry,
well.
I think I've got it.
Yes, so sorry, paragraph 36. So it says, although the intention to file, sorry, this is page 1545, although the intention to file a jurisdiction challenge was announced with the defendant's acknowledgement of service on the 28th of October 2020, no application was filed until the 7th of December 2020. That is approximately 26 days out of time.
Can we just look at the actual wording of the rule in this case, please? Where's that?
It's RDC 12.5, I believe. It's not, the rules are not in the bundle, but that reads, if the defendant files an acknowledgement of service and does not make an application disputing the court's jurisdiction within the period specified in 12.4, and 12.4 requires it to be made within 14 days after filing an acknowledgement of service. And then 12.5 says, subsection 1, he is treated as having accepted that the court has jurisdiction to try the claim.
Yeah, okay. All right. Now, what do you say about his points to the effect that in the circumstances he should
Sorry, I didn't catch that.
So he's, and just in this case, so he's, on your calculations, he's 23 days, they're 23 days late.
Yes.
And what do you say in response to the submission that in the circumstance of this case, it would be unjust not to allow them to challenge jurisdiction?
I would like to take you to the next decision, which is at 1396, which is relevant to this point. And in the application challenging jurisdiction, which is at page 35, it refers to the different agreements and the jurisdiction provisions. In this case, at paragraph 4 on page 1396, halfway down that paragraph, it says, in my judgment, where jurisdiction issues are to be raised, they should be spelt out in an application contesting jurisdiction.
Sorry, which paragraph are you reading from?
Paragraph 4, about halfway down the paragraph. And it says it should be spelt out in the application, not merely included in a skeleton shortly before the return date. The application was evidently filed on the 25th of April, which was far too late. And there's no, until my learned friend came on board, there was no arguments being advanced about lateness or excuses for lateness.
Yeah. Okay. All right. Are there any further points you want? And so far as the substance of the points of jurisdiction is concerned, I think you've already made your submissions, haven't you?
Yes, we've made submissions that there are sweep up provisions in all of the agreements that we rely on, as is very common, as you know, with lending agreements. Banks want the option and flexibility to sue in the appropriate jurisdiction. I've set out in my skeleton arguments why the DIFC courts are the appropriate jurisdiction, because there are assets here. The DIFC courts will apply the Swiss law and Hong Kong law under the agreements without issue by reference to expert reports, if that's what the judge decides he wants. And it would be much simpler for a judgment to be enforced in Dubai, because as matters stand, and because Mr. Jimmer has not complied with the freezing order, all that we have managed to attach so far are real estate assets in Dubai, which he says are all encumbered, but are not. And so with that in mind, it makes absolute sense for the DIFC courts to exercise its jurisdiction under the sweep up provisions in the agreements and under the DIFC agreement itself, and allow a sensible determination of the cause of action and enforcement.
Okay. All right. Anything more then you want to say about jurisdiction before we come on to this question of default judgment?
I don't believe there's anything else I need to say about jurisdiction, other than I think I've previously made it clear why, of course, the first applicant has the jurisdiction of the DIFC courts, it being incorporated in the DIFC and being regulated by the DFSA.
Okay. All right. Now, the default judgment, I have to say, I'm not immediately attracted to it. I'm not at all sure it's listed before me today. That may not be determinative, but it also seems to me that on the face of the particulars of claim, it's accepted there's an error in relation to how the principal sums are put together. It certainly doesn't seem to me, on the face of the particulars of claim as currently set out, that how one gets from the credit balance of 6.5 million to the negative balance of 4 million euros is clear at all. You've referred to the possibility of amending the particulars of claim in relation to the matter going forward. And at the moment, it seems to me that issuing a default judgment in those circumstances is unlikely to serve any purpose, because it seems to me that a response would likely to be that there's real issues which need to be tried in relation to the matter, certainly on the material at the moment. And I'm inclined to the view that that will be correct. I'm not at all sure that, absent everything else, the correct order in relation to this is for you to file any amendments to the particulars of claim that you consider appropriate. Assuming, of course, there's jurisdiction, all the other points which would lead to the particulars of claim still being there, and then for a defence to be put in within a defined time thereafter. Now that's not a binding ruling, but it's telling you where I'm presently going in relation to the question of your application for a default judgment. So how would you like to respond to that?
Your Honour, I'd like to, as I think made the point before, the actual debt itself has not been misstated in the particulars, of course, and
but it's as clear. It's as clear as mud as to how you get there. I mean, anyone looking at this intelligently and saying, all they're saying is we've got a credit of 6 million, we've got a debit of 4 million by way of unidentified particulars. I mean, how, leaving everything else aside, given that we are, after all, talking about millions of pounds or euros, it's pretty unsatisfactory, isn't it? I mean, the particulars of the claim is quite long, but on the key points, it doesn't really set out how you even get there.
Well, I accept that the calculation is not clear.
Well, it's not just the calculation; it's also that you put in £6.5 million into the fruit machine, and out comes €4 million, and what's happened inside the machine just isn't identified anywhere.
I would say it's split up in the table, which reflects the table and the information that I understand that Mr. Jummer receives, like you would with any.
Sorry, just to be clear, which table are you talking about? Sorry to.
This is the table at page 21 of the particulars, paragraph 12.4. We're dealing with 3 different accounts with different balances, and the amounts outstanding are then split up. And Mr. Jim has been aware of these figures for well over a year, not the interest, of course, because that's changed, but the principal amounts he's been aware of for well over a year. And he receives regular statements.
The table at 21, unless I'm misreading it, is simply identifying what is said to be the appropriate interest, isn't it?
It is, but it's also giving the capital amount for each account.
But how do I relate this back to the calculation of how you get from the £6.5 million to the €4 million?
I accept the calculation further up is not clear.
No, but sorry, my point's separate. You've taken me to this table. I don't think this table helps me in that, does it?
It doesn't address the earlier point that you raised, okay, Your Honour. I appreciate that.
Right.
Okay,
well, I mean, I say you've heard where I'm provisionally going. Now's your chance to persuade me to take a different course.
I would make the point that if the respondents were concerned about the calculation, they should have asked and could have asked. Weeks have gone by where they've actually acted in blazing disregard of your freezing order and have performed a dance with us in terms of the provision of information for weeks, where they've said they're going to give it, and it never comes, or when it does come, it's wholly inadequate. This is, I would say that the amount that the applicants are seeking is correct. The figure itself is correct. I appreciate that there are some unfortunate errors in the breakdowns or calculations, but the figure as it stands in the particulars as being the principal outstanding is correct. There's no real arguable defence to this claim at all. Mr. Jim has known about the principal amounts for over a year. No one has questioned it until this this today, really, or until the skeleton arguments were served, or when the ambush happened at the last hearing.
Okay.
And so,
all right. Sorry.
I'd say, if they wanted to raise it and have it as a valid point, why didn't they ask for the breakdown, or why didn't they ask Mr. Jummer to give them the statements that he receives from EFG by email all the time?
Okay. All right. Anything more on the first set of issues?
I don't think so. I appreciate I've taken quite a long time.
Well, to be fair to you, I don't think you've taken any longer. Indeed, I think you may have taken slightly less time than Mr. Fairseagle. So, insofar as you,
I think it was twice the time, Your Honour. But
sorry,
I think it was 2 hours versus 1 hour. But
was it? Well, anyway. Now, Mr. Fairseagle, you've got points in reply, no doubt, to what Ms. Bajulani has said. I'm inclined to think that they're likely to be quicker and more focused if I give you the lunch hour to think about what you really need to say by way of reply, rather than dealing with them now.
I was about to start speaking, Your Honour. I'm very happy to,
whichever
is more convenient for you.
How long is it going to take you to reply?
20 minutes maximum, I think.
I think in that case we will take the break now. We'll come back at 2 p.m. Now, just so far as where we are, after this we're going to go on to the committal arguments. I fear that my suggestion I might be able to give a judgment today is looking a tad optimistic in the light of where we've got to. But that doesn't mean that I want the committal arguments to take any longer than they have to. In terms of the committal arguments, I think it will be for Miss Bigiolani to go first. But I think in relation to the substance of the committal, I appreciate that Mr. Fierce-Eagle has got some, what I will call from the moment, without any necessary prejudice, some technical arguments. And I also want him to explain his point in relation to the construction of the order to me. But we'll also be dealing with the substance of that. But I don't want that to take any longer than it has to, if I can put it that way.
My clients were well, certainly I was delighted when you said you might give a judgment today. I wonder if Your Honour still considers he'd give a judgment with reasons to follow, or whether...
I'm not inclined to do that in a case like this. I think that giving a judgment with reasons to follow is fraught with the potential difficulty, which all of us come across, that when the reasons come out, one realizes that one's got something wrong. If I'm able to do it, it will be a judgment with reasons given there and then. If not, it won't be. And I'm afraid, so far as I'm concerned, I've got an absolute hard deadline of 4 p.m. GST. So it'll only be if I'm satisfied I can give the judgment. I think it's very unlikely I'll deal with costs, but anyway, it's possible I'll still be able to do it if we've dealt with all matters by 3 p.m. But I think that's pretty optimistic. I think it's more likely, I'm afraid, that it'll be reserved. All right. Well, thank you very much. We'll come back at 2 p.m. GST,
which is in 1 hour.
Which is in 1 hour.
Yep. Thank you.
Thank you.
Is everyone here who needs to be here?
I believe so, Your Honour.
Thank you. Mr. Fierce-Eagle.
Thank you, Your Honour. Yes. I said I'd be relatively brief, and I will try to keep my word on that. Can I just start by saying something just very briefly about your role today in what is quite a new jurisdiction, and where judges have an obligation not only to do justice as between the parties, but also at this juvenile stage of the jurisdiction play an important didactic role for others who might read those judgments. And I think that is a fact which comes to bear here, in terms of the opportunity the court has not only to do justice between these particular parties, but also to give guidance to lawyers practicing this jurisdiction as to how the duty of full and frank disclosure should be complied with on or without notice application, not least in circumstances where Ms. Bigiolani gave examples of other times that she has appeared before the court and operated in a similar fashion, by which I was slightly surprised. One of the allegations she makes against me is that I misled you. I didn't totally follow.
Well, look, she said that you should have brought to the attention of the court on last hearing the decision on an inter-parties hearing. You don't need to trouble me about that particular matter.
I was going to take you through the case and explain why it doesn't apply. If it's not going to help you, then I won't, Your Honour.
Well, it seemed to me that on my reading of that case, it was very far from clear what the allegations of full and frank disclosure actually were. It also seemed to me that the substantive issue in that case was as to whether or not, in fact, there should be a business exception applied, which is a different question as to whether or not, at the very least, the real possibility of one being imposed should be there or not. That's what I took from that. But if there's something additional which I missed, you can let me.
I don't think I need to take you to it. The only additional points I point out was that there was an attempted variation of the order 10 months after it was made by a company which was alleged to be non-trading with a claimant.
I confess I hadn't picked that up, so it's a good thing you did point that out. It was a 10-month variation.
Yeah. And with a claimant that said they had a proprietary claim to the assets.
Yeah.
One further matter I bring to your attention is it's
I mean, just on the point you made earlier, I think it might be fair to say that the jurisdiction is now adolescent rather than juvenile.
Forgive me.
But no, of course, in this field it is of importance. But you can take it that the court is well aware of the authorities which you referred to. I mean, one of the points which you'll no doubt address me on is if I were to agree with you that you're shooting at an open door so far as the full and frank disclosure is concerned, you might want to just make any brief submissions in relation to the point about the reimposition of a Mareva injunction in the light of the passage quoted from Christopher Clark's decision by Mr. Justice Jacob, but yeah, you'll no doubt come to that in due course.
Well, I'll just do it by introduction now. You can anticipate what my submission is going to be, not least because of the egregious nature of the breach, not least because of the fact that on my submission there is no, in fact, claim at all here. And you'll also have bear in mind, because at the first hearing on the 12th of May, I asked you to read it, and I could tell my lord had read it before the paragraph 7 of Tugashev in relation to. So you have the points on that, but just before
well, just to be clear, just to clear your point, you make paragraph 7 of Tugashev. That's the well-known point that just because it would have made no difference, or was likely to have made no difference, isn't expressly material. That's the point you're referring to.
Yes, and that the starting point is that it should never is that if there has been a breach of the duty of full and frank disclosure, the starting point is that the order should be discharged.
Yes, well, you should, so far as I'm concerned, you're shooting at an open door as far as that is concerned. That is a slightly different question.
Of course, no, it is.
It should then be reimposed, but that's because apart from else, once the order has been discharged, and one is looking at the question is whether it was being reimposed. One is looking at the whole situation in the round at the date of reimposition and so forth.
Of course. And on that, you have my submissions not only in relation to jurisdiction, but also in respect of whether each of these claimants has a claim at all, and whether each of these claimants has a claim against each of the respondents.
Yeah.
And I don't want to go over old ground on that, but those are, in my submission, very powerful reasons, both as to why this was a breach of duty of full and frank disclosure, and as to why the order should not be reimposed. But just sticking with for one further moment on the SMB case in relation to the allegation against me, paragraph 22 records that the business.
Sorry, just for my note, can you just give me the page of that within the bundle?
Yes. The authority begins at 2287, and the specific paragraph which I'd ask you just to look at, if, as I said, it's a very short point, is at 2290, and it's paragraph 22.
Yeah.
Where it says that business exception strikes me as a good example of a provision that will usually, perhaps nearly always, be appropriate in the circumstances wherever an interim freezing order is sought. So, I mean, the notion that this authority means that you can just cut it out and not tell the judge that you've cut it out, and when the judge asks you if you've cut anything out, say you haven't, is in our submission for the birds. One of the things my learned friend said in her submissions to you was in relation to the calculation of the claim and what my lord called the fruit machine point.
Yeah.
her point on that is that if there was any doubt about the calculation, we could have asked. That, of course, comes with two problems for the claimants. The first is that I couldn't possibly have asked an RFI of the claim in circumstances where I was disputing jurisdiction.
Yep.
The second is that the burden is on her, and that you'll see at Tugashev, paragraph 7, sub 4. I can take my lord to it if that's going to be helpful.
Well, no,
but
what would just give me, what would just help me is just in relation to Tugashev, if you give me the paragraph and if you could just give me the page so that...
the page. Sorry.
That's in the RJ section, I know, because if we had it before the court before.
And the page is of 7.4 is 1470, and it's the point that the applicant owes the duty to investigate the cause of action. I think the line is, yes, must investigate the cause of action asserted and the facts relied on before identifying and addressing any likely defences. So this is part of the central obligation of an applicant to get their house in order. Can I address now the point that's become a real issue since the skeletons and since my submissions earlier, which is in relation to the identity of the second claimant?
Yeah.
Limited, SA, AG. My learned friend made a sort of teasing point about language ability. It's very bold to accuse someone called Fear Siegel of not speaking German, but I'm not a German lawyer. But I can tell you, just from a sort of lay perspective, that in the same way in England, you see companies with LTD after their names. In Germany, you see companies with GmbH after their name, which is Gesellschaft mit beschränkter Haftung, which is company with limited liability. But when you get your phone bill, it comes from a company that has AG after it, Aktiengesellschaft, which means shares company. So as I said, I'm not a German lawyer, but I can tell you that limited is not a translation.
Yeah, well, you don't need to, as I say, my German is not, I'm afraid, that good, but my French is good enough to know that Société Anonyme, and indeed there are.
Yeah.
But I mean, what was said is that odd as it appears, AG is the same legal entity as limited. Now, that would seem to me to be surprising, but I mean, that's what was said.
Well, that was what was said.
Yeah. Okay.
And I think it certainly is. I would be extremely surprised if that were the case, but that was what.
I mean, I should tell you, perhaps to both of you. I mean, I did. I'm afraid, whilst Miss Bijai was speaking, just Google the English Companies House, and I couldn't see that there is a EFG Limited registered, EFG Bank Limited registered in England's Company House, although there did appear to be an EFG private bank or some other similar thing.
And a further limited company with a similar name, but no EFG Bank Limited. Who knows what EFG Bank Limited is?
Can I just say I've now got information about company codings, which, of course, I can share with the court after the hearing.
Well, I mean, given that what you said was on instructions, Ms. Bijlani, if your instructions have changed, I think
no, they've not changed. They've not changed. I've just been given company name and a legal identifier code, which explains. It seems I've literally just opened it, I have to say, on an email, but it seems to be an explanation.
Okay, well, I think we'll leave that for present purposes, because I think we're going to decide this on the evidence that we've got here today. Yes, so Mr. Fitz-Eagle.
Yeah, and it was then asserted that the first claimant had suffered a loss in relation to management time, etc., which is obviously not pleaded. It was then suggested that it had suffered a loss because the banking arm's loss via some accounting mechanism is attributed to it. That again is something which is completely unevidenced and unpleaded, and is probably irrelevant anyway if one looks at the terms of the agreement. My learned friend took you to clause 319 of the DIFC agreement. Perhaps we could turn that up on page 74.
Yeah.
And at 318, you have the exclusion of third-party rights. And of course, this is just claimant 1 and respondent 1 who are parties to this agreement. But then she said at 319, no person who's a party to this agreement, with the exception of any other relevant affiliate not being defined in the agreement, shall have any right under Part 10 of the DIFC law to enforce, enjoy any benefit from any term or provision of this agreement. So it's impossible to see really where this takes the claimants, because if the second claimant does, and we'll come on to that in a moment, have a right to claim for a breach of the agreement, it can, of the DIFC agreement, it can obviously only be for loss suffered under that agreement. And this is an agreement for what I described in my opening remarks to you as essentially a broker agreement. It is not under this agreement that any loans are extended. For obvious reasons, those are extended under the framework agreement and the supplements to it, subject, perhaps on the claimant's case, we'll come on to it, guarantees from the corporate and guarantees from the third claimant. But the 319 doesn't help the claimant at all, and it ignores, and perhaps it's helpful now to look at clause 2.5, which makes good the submission I've just made to you, which is on page 71. Which is that any transaction we arrange for you or advise for or may be executed by a booking centre, which is subject to regulatory transfer and jurisdiction. Any transaction executed by a booking centre brought about as a result of us providing you with the services, which are essentially broking services, shall be governed by the agreement.
I'm sorry, where are you reading from?
Clause 2.5.
Oh, sorry, that's why I can't see it. Yes, all right. Yes, yeah. Okay, go on.
Perhaps I'll just let my lord read that.
Yeah, I've read it.
So this agreement is basically saying we'll provide you with the services. There are no third-party rights in relation to it other than in respect of affiliates who might be able to sue for breach of this agreement. But if we do a deal for you with a booking centre, it's governed by that agreement. So there is just no way that the first claimant has any claim here at all. My learned friend also addressed you on the credit agreement, which she said was ancillary to the framework agreement. Perhaps we can turn the credit agreement up.
Just give me the reference to that.
Sorry. That's at page, it's just loading for me, 151. And if you scroll down to page 155,
yeah,
you see that it's signed on the 7th of April.
Yeah.
And if you now go to the personal guarantee, which is on 156,
yes,
you see there that that's an agreement between EFG Bank SA and Mr. Juma. And if you look in the third line under the rubric guarantee, you see reference to the agreement dated 7th of April.
yeah,
And it is common ground. It was already asserted in the Sandilla witness statements. My learned friend accepted it today that this transaction does not go through. No money is lent under the credit agreement that we just looked at a moment ago, which was a €100 million facility, because no collateral was provided.
Yeah.
So this guarantee guarantees a credit agreement under which no money was ever extended.
Now, for your purposes today, you're not seeking to strike out these claims.
No.
The relevance of these points goes to the existence or strength on the material before me of the case now brought by the claimants against the defendants.
Correct.
And given that they're not these points are not in your particulars of non-disclosure, I think you've said this already.
Correct.
They effectively go to, well, I suppose they go to two things. One is in due course whether or not it should be a default judgment, but they'd also go to the question as to whether or not I should reimpose an injunction. That's what they go to.
Exactly.
And for your purposes, you're saying these are very real hurdles which on their face present very substantial difficulties for the claimants. That's I think as high as you need to go, isn't it?
It is as high as I need to go. I mean, I would say I don't think there is an arguable claim by any of the defendants against the third defendant.
Yeah, all right. So I won't write you down, and that's what you're saying. But if it was slightly lower than that, you would still say that it was very material for the purposes of
totally.
assertion.
I'm addressing you now in relation to whether or not, if you accept my case on full and frank disclosure, there's any proper basis for the re-grant of this order.
Okay, that's very clear. I understand what you're saying. Yeah.
As an aside, that's not true for my submissions on jurisdiction. They do double duty. It's a failure to bring me to the court's attention.
I do understand that point. And to be fair, you made that point in opening. I was just wanting to check that I'd got it clear.
No, you've got it perfectly clear. And if we just very, very quickly go to the corporate guarantee at 255, you may say you've made this point to me already, Mr. Physical. Don't say it again.
What you can say is the reference again, because I didn't catch it. But see page
225.
Yeah.
My previous submission to you was about how they could possibly bring Mr. Jummer into all of this when they're suing under a guarantee in respect of a loan that wasn't extended.
Yeah.
This is all about how they can bring Arj into this when they're suing under a guarantee between the Aktiengesellschaft and Arj, which doesn't include a guarantee to the EFG banking group, only to other banks of the bank's branches or offices, the bank being defined as AG.
Yeah.
So you have that. You have my point on that, I think.
Yeah. Yeah.
My learned friend complained to you that I had said that this claim was being pursued under DIFC law rather than Swiss or Hong Kong law, and she didn't understand why I was saying that. Perhaps I can just take you to the part of the pleading by which that point is made.
Yeah.
Can we look at page 22?
Yeah.
Paragraph 14.2, she says EFG, DIFC and the bank are entitled to additional damages due to the breach of representations under the 2005 Act. And that's made good at paragraph 13. So, I mean, if I have been misunderstood, I think I can be forgiven. She does say that it's all subject to Swiss law, but it does seem also that there are being claims pursued by the bank at DIFC law. But there we are.
Okay. Yeah.
On dissipation of assets,
yeah,
which was an interchange you had with my learned friend in relation to whether there was such a risk.
Well, so the way she puts it, I think, is that the evidence which has come to light as to the misuse on her case of the Ernst & Young name substantially undermines the entire relationship between your clients and, putting it loosely, her clients, and demonstrates a willingness, not just in relation to peripheral matters, but in relation to critical assets, which leads to an appropriate inference of dissipation once Mr. Juma knows, to use a colloquialism, that EFG is onto them. That's as I understood the case you're having to meet on that.
Yes, I understand that to be the allegation. It just doesn't make sense. This is the Holyoke point, which you see, which is what I've referred to in the skeleton as the stable door point. If this is all a big fraud, and Mr. Juma, via Dr. Khan, procured these loans deliberately by providing false accounts, then the point at which the assets are dissipated is the point that the loan is called in, which is months and months and months ago. And what my learned friend has to prove is not that this chap is dishonest and might be the sort of person who would dissipate assets, but that in this particular case, at the moment the order is being made or remade, there is a risk of dissipation. If she was presently saying, you've got this loan facility at the moment, and it's in the red, but we know you're good for the money, and then she had discovered that some material dishonest representation had been made, that would be an ordinary circumstance in which you come to a court ex parte and say, I've got this customer, I'm on to him. He doesn't know it yet, but I am. Give me a freezing order. But when as actually happened here, he misses, it's a completely ordinary commercial transaction whereby the chap misses the margin call and you then call in the loan, and you've been asking him, writing him letters saying, when are you going to give us the money? The idea that that gives rise to a risk of dissipation now when the order is made is a total nonsense. And you know it
isn't the way that it's put forward this, that just to test this, what isn't known by Mr. Juma is that EFG is onto the fraudulent use of Ernst & Young's name to justify the original loan. Now, true it is that they've been pursuing him for what, in the context of some of these details, is relatively small amounts of money. In other words, mid-single figure millions in terms of euros. But the attitude of a bank to the knowledge that it's out of pocket to the tune of 4 million euros, in circumstances where there's been a margin call, as you described, is rather different from one where it's suddenly discovered it's been hoodwinked from the start. And
well, yes,
Mr. Juma might well, in those circumstances, then think that EFG are going to be rather more anxious to pursue him than has otherwise been the case, and hence dissipate. Now that's how I see the argument.
Yeah,
potentially having some validity.
Let me address you on the hoodwink from the start point. That presupposes, and it's difficult to glean from the particulars of claim this was not the case, that the bank took a lending position on the documents which are said to have been forged. Yeah. As I understand it, my learned friend will correct me if I'm wrong, they never actually extended any loan in relation to any of this.
Yeah, okay, so your first point is, well, where's the link between Ernst & Young and these loans?
Yeah,
I've been asked to correct it wrong, but to avoid further submissions, the loan was advanced on the basis of the OCME bond, which is referred to in the supplemental framework agreement, and as is the coupon payment that was due.
Well, I don't understand that actually to be the case, because that requires there to be a loan value ascribed to it and sums then to be advanced in relation to it. And I haven't seen anything that suggests a loan value is ascribed to that bond and a loan value is and then fund sums are then extended in relation to it. How I understood that was going to work was that the coupon payment was going to come in, and the coupon payment was then going to be reinvested by the bank, i.e. they would hold the loan that they were providing in relation to it. And because the coupon...
I don't want to have a back and forth in relation to this. There are limits to what I am, and I'm not going to decide for present purposes. You, Mr. Fierce-Eagle, are on the point in relation to dissipation that the link between the Ernst & Young reports and the lending is far from clear. That's the point you're on.
Yeah, that's the point I'm on, and it has this. And again, this point does double duty, both in relation to full and frank disclosure, and whether even now the claimants have done anything to persuade you there is a risk of dissipation. Can I take you to Lacatamia Shipping very briefly on this point? And I've quoted it in the skeleton. You may say that you know all of this, but the point on it is that there need to be solid. It's not enough just to say this chap is a bad egg.
Yeah, no, I mean, I've got the general point. If you would just give me the reference, so I can look at it and remind myself.
We were looking at it before, where it was quoted in Apparel, which is the easiest place to pull it up. It starts on page 1772.
Right. Yeah.
And if we look at there quoted from Lacatamia in Apparel 34.4, which is over on 1773, it is not enough to establish a sufficient risk of dissipation merely to establish a good arguable case that the defendant has been guilty of dishonesty, necessary to scrutinise the evidence to see whether the dishonesty in question points to the conclusion that assets may be dissipated. And so, as the respondent in this case, we say to you, the fact that Dr. Haider is alleged to have produced accounts which are in turn alleged to have been fraudulently produced, you may consider there's a good arguable case on that, but that does not lead to any appreciable risk significant for meeting the relevant test that assets are going to be dissipated here. That's true a fortiori now that they've gone on and enforced your without notice order onshore and found out about all these properties, which they say are unencumbered. That's their case. And of course, unencumbered properties onshore are very, very difficult to dissipate indeed. And so what is it that they say? Why do they say there is a risk of dissipation here? I mean, to the extent to which they're scraping the barrel is shown by the fact that one of the things they've relied on in the witness statements is the fact that Mrs. Jummer once said, apparently is said by someone else to have said that she went to Eton. I mean, they may have a good arguable case in relation to dishonesty. I put it no higher than that. I haven't investigated it. I haven't taken instructions on it. I don't know. But it's not enough to prove a real risk of dissipation.
Okay. I've got your point.
But then addressed you in relation to transferred loss. I can address you on that if you'd like to hear from me.
No, I mean, it seems to me that in relation to an unpleaded allegation of transferred loss, if she needs that to get where she's going to, then there's some difficulties in relation to that.
Yeah. She also said to you that the second respondent is not a trading entity. I wasn't aware that there was any evidence to that effect, but there we are.
Yeah,
it's a.
Yeah.
I said I'd be.
I can take you to the evidence because it's an email from Dr. Khan that says it's a non-operating company.
Well, in due course, you can just give me the at the end of that. You can just give me the reference to that, Ms. Vigilani. Right, Mr. Fierce-Eagle, how are we doing in relation to your reply submissions?
That's it from me.
Very good, Ms. Vigilani. Do you want to just either now, just give me that reference? Then we're going to move on to contempt.
Yes, I'm just checking it. I should have it shortly. I would just like to make a couple of points very quickly about the default judgment issue, if I may. The the particulars of claim that we did look at earlier set out.
Really? Sorry, are these points? What are these just points that you wish you'd made before lunch, or are they? What else are they?
Well, I think what I want to invite you to do is to allow the applicants to file further evidence to explain why the amount being claimed in the particulars of claim is due. And you know, as I said, you know, the calculation involves liquidation of guilt, which is set out in the particulars of claim.
Ms. Vigilani, what I indicated on a provisional basis I was going to do, if one gets to the point where there is still particulars and so forth, it was to give you an opportunity to amend the particulars, which would allow the calculations to do, and then to set a time for Mr. Fear-Siegel's clients to put in a defence. That's what I indicated on a provisional basis I was minded to do in relation to it. Now, putting in further evidence about this doesn't really seem to me to meet that particular point.
I would suggest that, you know, when you look at the Bank of Singapore case and the extensive ludicrous arguments that are advanced in that case and the costs that must have been involved.
Well, just on the costs involved, I mean, there's already over $600,000 being expended on your side in relation to this. I mean, that's not insignificant.
Yeah, agreed. It's not insignificant, not helped by being ambushed, rather unethically, I'd say. But I take the point that perhaps the calculations could have been clearer, but the debt position, as stated in the particulars of claim, is not incorrect. The debt figure
so the point
is
you
correct.
You want to ask me to give you the opportunity to put in to give a default judgment and then for further evidence, or what's your point?
To submit an affidavit of Mr. Sandilla that explains and exhibits a statement that shows you how the end figure is arrived at.
No, I really think you have more than enough opportunity to deal with all of that before the hearing of this. I'm not adjourning this matter so that that can be put in.
But Your Honour, can I just say you were not minded to hear the application at all at the beginning, the default judgment application at all, and pointed out that it wasn't listed before you.
Well, I thought you were saying that you did want it heard.
Well, I want it heard on a fair basis, I'd say, and I don't think it's fair that this point is being taken in the way that it has been taken in a situation.
What's not fair?
It is not fair in the circumstances where there's clearly a basis for default judgment. We're being forced to incur so many legal costs with, as I said, the unethical ambush that was made. There's a clear debt that's due. The jurisdiction argument is gone. They failed to file the defence. In the circumstances where you have evidence that this debt is due and owing, it's a case where default judgment should be given, rather than this court incurring much more time, having extensive submissions, pleadings and hearings and evidence, dealing with the matter later on.
Well, there is nothing, I think, to stop you filing an application for summary judgment in due course, if that is appropriate. At the moment, we're on the position as to whether on the evidence before me, and as a result of an application which you issued and which you urged me to hear on the 12th of May, I should give you default judgment on the present state of the matter. You're now, I think, asking that application shouldn't be determined.
I'm saying that there's a perfectly credible explanation in the particulars of claim of the calculation if we reread the paragraphs in terms of the actual loan and the guilt liquidation.
You had 2 hours before lunch to make these points. You're the one who wants to get on to the contempt application. We're now on an application which was filed late, where you first of all wanted me to hear it, now you want me to adjourn it. You're now asking, are you, for the default application to be adjourned so you can put in additional evidence in relation to it? Is that what you're saying?
I'm saying the default application was filed before my learned friend made his points about the figures. And, you know, these are points that he should have made a long time ago. And his point about asking for further information could obviously be made without prejudice to the jurisdiction points.
Well,
That's
right.
not an answer.
Is there anything more you want to say on that?
I'd just say on page 147 is the email from Dr. Khan to EFG saying that the Cayman entity Arj is non-operating.
Sorry, 147.
147.
Thank you.
All right. If you want to hear my part on that, Your Honour, I'll address you. Otherwise, I won't.
Well, I suppose, what do you say about the suggestion that the default application should not be determined?
Oh, the default application. Well, I'm very happy to address you on it. It's an application that stands no prospect of success at all. So I can deal with it very briefly if you'd like.
Well, no. I mean, if that's your submission, I know what you would. Well, I think I know what you're going to say about it. So, yeah.
I'm happy to leave that to you, Your Honour. If you want to hear it now, I'll argue it. But if
well,
not,
no. I mean, look. No, I don't want to hear it now. Contempt. Ms. Bijlani, it's your application in relation to contempt. You deal with it at the beginning of your skeleton argument. I mean, I've got your points in relation to timing and so on and so forth. I will want to hear you substantively in relation to the construction argument put forward by Mr. Fear-Segal, but I'm in your hands as to whether you want to address that point now or address it in reply, either as far as I'm concerned is satisfactory in relation to his construction point. But are there any other points that you want to make in relation to your contempt application?
The construction point that I understand you're referring to is how you interpret paragraph 2 against paragraphs 8 and 10. Is that correct?
Well, that's the point taken by Mr. As I understand it, by Mr. Fear-Segal, yes.
Yeah, I have to say I consider that argument to be utter nonsense, in the sense that paragraph 2 is dealing with the situation where there is an application to vary or discharge the order. And it's only if there was obviously a variation or discharge that the wording that appears at the beginning of paragraph 8 would have any effect. It's not the case that if there's a basis or if an intention to make an application to vary or discharge is out there, that paragraph 8 applies. I mean, that would be an absolute absurd situation. Only once the court varies or discharges the order can it truly be said that paragraph 8 doesn't apply.
All right. Well, I've got your submissions on that point. If you want to say anything further, having heard from Mr. Fear-Segal, you can do so. So far as the other aspects of the your application and your amended application in relation to contempt, as I say, I've got and have read your skeleton argument in relation to this, starting at paragraph 6 and going through until paragraph 20. Are there any particular points that you want to emphasize there?
Yes, there are. If I could take you to one of the authorities that's referred to in my skeleton, which is Latif. Just trying to find the correct starting point for that. Apologies.
Sorry. Starts at 1638, I think.
Yes, so this is a case, this is very much at par with the kind of case we're dealing with here, where a number of relevant points were decided, and which I'd like to refer you to. First of all, in this case, the person accused of the contempt was asked to attend court for the purpose of being available for cross-examination. And if I can take you to after the analysis in the judgment of the relevant principles to apply for contempt, which I won't stress you on because I'm sure you're familiar with them. But if you could have a look at paragraph 24 on page 1629. And this is where in the judgment it's being stated that the rules should be construed as permitting the court to exclude from evidence an affidavit in a case in which a deponent appropriately required cross-examination is not produced to give evidence.
Yeah.
And if you go further down in the judgment, you'll see at paragraph 28.
So just on that point, that's the point that you make in your skeleton argument.
Yes, paragraph 15, skeleton.
I mean, I take that point. You rely, though, to some extent on what Mr. Juma says.
I do, but what the point I'm making is that, to the extent that he tries to give excuses of not having disclosed real estate assets on the footing of suggestions that he only owns 20%.
Your point, I think paragraph 15 should be restated. So it said, should disregard Mr. Juma's evidence insofar as it seeks to avoid or minimize his liability for contempt. That's really what you're saying.
Yes.
Yeah, okay. Yeah, all right, I've got that point.
Fine. Yeah. I was going to take you to the affidavits of Mr. Sandilla, just quickly, just to give you, or to refresh your memory rather, in terms of what it is that was presented to the applicants in terms of the assets and the worth of the companies and Mr. Juma. And I want to do that because, as I've said before, Mr. Juma presents himself and his companies as having an awful lot of money and assets, and it's quite frankly remarkable that it's being said that all these assets have gone, just by reference to debts of, I think, just over 50 million in favour of Bank of Singapore, and 60 million or so in favour of Deutsche Bank. This is a man who says he's worth billions.
Where are we?
If I can take you to...
No, where are we? Which points are these amplifying in your skeleton?
These were in my first, in the first skeleton I served before the 12th of May hearing. I set out all the detail in relation to the background to the transactions.
Okay, let me just get so just so that my note I've got where this is going. So this is the applicant's skeleton argument for the 12th of May hearing, is that right?
Yes, I didn't repeat it in
Sorry.
the skeleton
I'm just seeing where we are. Okay, so that starts at 957, and where is it within that?
It's at the very beginning of the introduction. Sorry, is it 9? Did you say 947?
I said 957.
Yes, if I remember correctly, it's at the introduction section. where I set out, after the applications, I set out the overview of the applicant's position.
Yeah.
And
So just
explain.
so just go so
Yes.
so 959.
Yes. So from paragraph 5.
Yeah.
Explaining how this lending came about at all.
Yeah. No, and are these the points you want me to take to Sandilla?
Yes. I mean, you could just read this
Well,
as a quicker alternative.
That was what I was going to suggest might be quicker.
Okay.
So let me just remind myself of this. So you want me to read from paragraph 5 through until where?
Through until I guess 17, really, because then it's general principles which are set out, which are already to some extent covered in the skeleton for today's hearing.
Yeah.
And then, sorry.
Wait a second. Wait. All right, so I read 5 to 17. Yeah.
I was just going to go back to Latif again, because I was taking you to a point in relation to the failure to provide information.
Yeah.
This is at 1639.
Yeah.
Paragraph 1.49, 150 and 151, where it says it's difficult to overstate the significance and gravity of the contempts in relation to the requirements of the second worldwide freezing order relating to the provision of information with respect to their assets. And I've set out in the skeleton other cases where a failure to give information in accordance with what is paragraph 8 and have it confirmed in paragraph 10 of the freezing order is a serious contempt of court.
Yeah.
As
just remind me what penalty the
DIFC courts.
No. What penalty the Chief Justice imposed in Latif?
Page.
So in relation,
having I mean, normally it's fines against corporate bodies and a referral to the Attorney General for individuals.
Well, yeah.
And costs.
We'll leave to the side one costs. I think I haven't looked at it. Is there some guidance recently from the Court of Appeal in relation to this or not, in relation to how you go about assessing the question of penalties or not?
Not that I'm aware of. I have appeared before the Court of Appeal in another case on Gulf Wings, where contempt was found and fines of, if I remember correctly, $100,000 were imposed on the corporate defendant, and a referral to the Attorney General of the directors accused and found to be guilty of contempt.
Okay. All right. All right. Well. Okay. So, all right. I've read what the Chief Justice did in Latif in relation to that matter. Yes. Where else do we go?
So, if I can take you to if we can quickly just look at the order again, and paragraph 8 and what it specifically says. So if we go to page 42, paragraph 8 requires the respondents within 48 hours of notification of the orders, and to the best of their ability, to inform the court, inform the applicant's legal representatives of all assets worldwide exceeding $25,000 in value, whether in their own name or not, and whether solely or jointly owned, giving the value, location, and details of such assets. And then in paragraph 10, of course, you've got the provision requiring affidavit evidence to be served within 3 working days after being served with the order, confirming what's set out. And at 725 onwards, you've got various certificates of service in relation to the freezing order, and it was notified, I believe, on the first time on the 12th of March, and it wasn't then until the 17th of March that we then receive an affidavit from Mr. Jummer, and that's at 574. And this is the affidavit that at paragraphs 10 so this is 575, paragraph 10 says he needs more time. It's my intention to comply with the order. Then at paragraph 13, he says, I need at least 4 weeks to comply with the order, specifically the provision of information directions. And in such circumstances, I request that the court grants me this time. At 435 is the exhibit that is produced, which is I think it's labelled MJ1. And this states at page 435, so for Marge, entity does not hold any unencumbered assets. All assets held with Bank of Singapore are encumbered to the tune of 55 million. And then effectively the same is said for Arj. All of its assets are encumbered allegedly to Deutsche Bank Singapore in a contested claim of 86 million. And then Mr. Jummer, all assets are encumbered. He doesn't hold any free assets. He needs 4 weeks to comply, and they rely on the scope report, which was put before the court when the freezing order was obtained. Now, if you remember, on the 20th of March, when we had...
I've just reread down to paragraph 39 of your skeleton argument for the 12th of May. And I don't want to put words in your mouth, but it seems to me that the essence of what you're saying is that he didn't comply with the letter of the contempt order. He said he needed more time, but there is no evidence that despite that extra time, he hasn't complied with the provisions, despite the fact that he's had from whenever it was served on him after the 10th of March until to date to do so. And the affidavits which you deal with in your skeleton argument really show a continued package of obfuscation. Is that fair?
That is correct. And you'll see that in each of the affidavits, Mr. Jummer repeatedly says, I need more time. He makes excuses that it's a process of investigation, that he's reliant on other people assisting him to get the information. I mean, someone charged with contempt, or well, given that this application for contempt was made some time ago, but you would at least expect much more explanation of what it is Mr. Jummer is doing to get the information, evidence of the difficulties he claims he's had. But there's nothing. There's just a repeated series of excuses,
Right.
which are not substantiated.
I've got the essence of the point, and I've got the point you made earlier that in the light of his failure to appear for cross-examination, the excuses, as it were, shouldn't be taken account of. But I want to just focus upon the penalty. Now, reference to the Attorney General might, or might very well not, lead to imprisonment. The normal thing that people want from contempt is enforcement, compliance, albeit belated, with the court's order. And in the ordinary course, it may very well be that a provision saying that unless the order is complied with by X, a penalty will be encouraged or will be involved with continuing thereafter, better meets the objective of seeking to enforce compliance with the court's order than anything else. And my recollection is that there's some authority to that effect in this jurisdiction, but I may be wrong. What do you say about that?
I did reference this, Your Honour, at the beginning of my skeleton, where Sir Jeremy Cook, faced with a situation where a party has not complied with the provision of information. I can take you to that authority. It's at 1.
No, just remind me, sorry, which skeleton are we in?
The skeleton for today's hearing.
Okay, so let's just go back to today's hearing. So which paragraph of your skeleton?
Paragraph, well, this is 1 to 5, which is to deal with my point that the respondent should not be heard.
Well, that's a different point. That's the point that I thought that
I take it as a different point, but what I'm saying is that in that case, there was a finding of contempt for failing to provide information, and the direction that Sir Jeremy Cook took was to give in against a position that he had decided in that case, that because of the contempt, he should not hear other arguments from the other side, which is a point I was making in my skeleton at the outset, based on established principles.
I understand you to be saying, and I'm not suggesting you withdrawn it, that the appropriate overall response to this is that notwithstanding any non-disclosures there may have been, etc., the failure to comply with the order means that until he's purged his contempt, nothing should happen. And I understand that point, and that's fine. I'm on a slightly different point, which is that on what you actually want from contempt itself on the hearing of the application, I thought what you wanted was a reference to the Attorney General in the case of Mr. Juma, and monetary fines in relation to the other defendants. What I'm asking about is whether or not actually it might be better at that stage to order monetary fines in the event that proper information isn't provided.
I submit that's not the correct course to take. There's clear evidence of contempt in this case. The correct course I submit should be taken is a finding of contempt today.
Well, I mean, but that's fine. I mean, so I find that we're on penalty at the moment.
Yes, and I say that on the finding of the contempt, the penalties should be applied and costs. If Mr. Juma and the other respondents want to purge their contempt, they can be given the opportunity to comply with the freezing order by filing affidavit evidence that gives the information about assets that they should have done, but that does not absolve them, one, of paying the fines and the costs, which should follow on an indemnity basis, and it doesn't stop the DIFC courts from making a referral to the Attorney General in the meantime.
All right.
And so that, I submit, is the position that should be taken, and it's appropriate because clear evidence of contempt, and this is the only way to try and make the respondents comply with the order.
Okay.
Can I think in Jumma 2 at 577, he does, of course, say that I confirm, this is on page 578, I confirm that no steps have been taken. And then he goes on at paragraph 6 to say, I confirm that no steps will be taken to dissipate assets. I say that that statement is all very well and good, but it's just not good enough to satisfy the applicants that Mr. Jumma means what he says in the face of evidence of fraud.
Well, what else should he say?
Well, I'm saying that doesn't excuse his non-compliance. So in the sense that just because he confirmed in affidavit 2 that he won't dissipate doesn't mean, one, that there is still a high risk of dissipation, and two, he has to comply with this order. The statement that he makes doesn't excuse his non-compliance.
Right.
And then in Jumma 3 at 579, again, paragraph, this is what the statement given on the 24th of March. Again, he paragraph 9 on page 581 reiterates he intends to fully comply, complains at paragraph 14 that information is extensive and comprehensive, that several entities are involved, that the process needs investigation at paragraph 21. And then he goes on and says that all the assets are encumbered. He keeps saying all the assets are encumbered at paragraph 51. But as I said, if you're faced with an allegation of contempt, any sensible person, an honest person, would give proper information about what it is they allege they're doing. Instead, he just gives absolutely nothing. If I can then take you to page 447 of the bundle.
Yeah.
This is a document that was obtained from the onshore Dubai courts following the recognition of the freezing order onshore Dubai. And as you may know, what happens is the court will write to the land department, to the banks, and it will ask for information about what assets are held in the name of the respondents. And this document lists various properties that are in the name of Mr. Jumma. And so you can see at top of page 447, in relation to plot 434, it's got the name of Mr. Jumma. That property says it's fully mortgaged. That, in my opinion, means it's mortgaged up to the limit that's permissible in the UAE. But if you scroll down, you will see on page 447 another property, freehold property, not encumbered. 448 has got 3 other properties, not encumbered. 449 has got 3 more properties not encumbered, as has 450.
Yeah. So I mean, this is all clear evidence that full disclosure hasn't been given despite the orders. That's the point.
Absolutely, it just hasn't been given. And you know, there's even more evidence of securities at 466 that the applicants have learnt about from the Dubai courts. And again, this information about securities not disclosed, no evidence that they're encumbered as suggested, but 466 and 467 gives you details of yet more assets that he claims were encumbered, and they're not. There's absolutely no evidence that they are. And then Jumma 4, starting at 595, he then tries to address reactively the evidence that's been put to him by Mr. Sandilla in relation to the real estate assets at paragraph 26 on page 599. So the first 2 properties, I only own 20% in these properties, and in any event, they're entirely mortgaged and attached. This is not the information that the order that you made required him to provide. Paragraph 8 is very clear, and I'm sure his lawyers advised him. He needs to give details of assets that he owns in his own name or not, and whether solely or jointly, giving the value, location, and details of all such assets. Instead, we've just got this vague statement in his 4th affidavit claiming that he owns a minority share. Well, that is an asset. And it's remarkable that even if it is the case that he only owns 20%, he concluded he didn't need to disclose it.
No, just to be clear, where's this document in your skeleton arguments?
You mean the real estate assets?
No, the point which is just being made here about the securities.
I believe it was in the earlier. Apologies, I think it's in the earlier skeleton argument.
Can you just tell me where? I've just been looking for it.
I'm afraid I've lost track of the.
So that
page.
Your earlier skeleton argument is at page 957.
I think the way I've put it, I haven't particularized in the skeleton bit, being given that it's a skeleton, every single point, but I have made the point at page 9 that he's saying all assets are encumbered.
Yeah, no, I've got your point that he says the assets are encumbered and there's evidence not. I'm just
it's in evidence.
Sorry?
The securities point that I took you to at page 466 is dealt with in the evidence of Mr. Sandilla in his 4th affidavit.
Right, and where is that?
That is at paragraph 23 on page 548.
Okay.
Then in Jumma 5, which starts at 603, Mr. Jumma provides details of some bank accounts in the name of the first respondent. And you'll see you've got, for example, BNP Paribas, status inactive, encumbrance 389. That there's no explanation as to how this asset is encumbered. And then further down on 604,
yeah, I mean,
it's got,
I've got
all these allegations of active accounts.
I'm sorry to hurry you along, Miss Bidgley, but I do understand your general points that there has been a failure to comply and that there is evidence which shows that there were unencumbered assets and you've put them forward. And those are the breaches you rely on. And the reason I'm hurrying you forward is I want to hear from Mr. Fairseagle. My hope that I was going to be able to give judgment this afternoon has rather gone by the by. But what are these additional points adding, if anything, to what you've said in your two skeleton arguments?
Well, I appreciate the time's ticking away, but I would just make the point that in the last statement.
Well, I want
Mr.
to know
Jimmer,
what point it is that you're actually alleging. I've got the points that there's apparent breaches. I've got the point that are encumbered and their assets. What point is it you're wanting to make in addition to that?
Well, I was just going to take you to
well, just tell me what the
fact
is.
that he keeps on saying he's going to comply, and as at today, he has not complied.
I've got that point. That was the point I put to you about 20 minutes ago and saying yes. I've got that point. Is there any other points you want to make?
Not at this stage, no.
All right. Mr. Fairseagle.
Thank you, Ron. Can I start by responding to my learned friend's response to my point on construction, which is where she says Mr. Fairseagle can't possibly be right as to what the interrelation between paragraphs 8 and 2 mean.
Well, let's get the order up first so that we can just have it. So just before we do that, let's have the order up. Yeah.
She says
it's the original order. Sorry, it's the order which is at page 548. Yes.
548. I look at it in an entirely different place. Let me just make sure that is what we're looking at the same thing. I look at the one that's on the screen at page 42.
Yeah. I've got it numbered 42 as well, but the same document. All right.
Great. So on what I call page 42, there's paragraph 8, which says, unless paragraph 2 applies. You'll have read all this in my skeleton.
Yeah.
And what my learned friend says is that must be wrong, because it would mean that in any case in which there was an order, in which the order was made without notice and the respondents had a right to apply to vary, the requirement of paragraph 8, into which an applicant puts the obligation of disclosure, would not apply. But this part of the hearing has echoes of the matters we were talking about this morning, because this numbering and the internal reference between paragraph 8 to paragraph 2 at the top of the order is the consequence of my learned friend's amendments to the standard form. This is not what an ordinary freezing order looks like. Can we look at Schedule A to Part 25, please?
Yeah. So are you referring to me, or are you looking in the practice?
I don't think it is in the bundle. I always look at it in my own copy. I wonder if the court. I usually ask.
I've got it. I've got it. All right. Yeah.
Thank you. And if we look under the rubric provision of information, we have paragraph 9, and of course in our order, because of the amendments made by the applicants, it's not paragraph 9. At subparagraph 1, unless subparagraph 2 applies, the respondent must best visibility, assets, etc., etc. And subparagraph 2 is if the provision of any of this information is likely to incriminate, he may be entitled to refuse to provide it, recommended to take legal advice. If we turn back to the order, that provision that would otherwise be at 9 subparagraph 2 is at paragraph 9.
Sorry to interject, but I think that's just misleading. That's not what the draft order says. I have it in front of me. It says 9, unless paragraph 2 applies, which is within so many hours provide information, which is what is in paragraph 8. And then another paragraph, also number 2.
Mr. Johnny, I'm sorry, I'm really not helped by backwards and forwards stuff in relation to it. You've got a right to come back in relation to this. And at the moment, we've taken up a lot of time, but it is very important at these occasions that council do not interrupt each other on these occasions. And at the moment, I'm simply wanting to understand what Mr. Fearsiegel's points are. If they're demonstrably bad, you'll be able to demonstrate them. Right. All right. Mr. Fearsiegel.
If this had followed the standard form, if we look at the order that was actually made on paragraph 2,
it would be saying unless paragraph 9 applies, is your point.
It would be saying unless paragraph 9 applies, and it would have been in a paragraph with 2 subparagraphs, and the reference to subparagraph 2 would be you take my point.
So paragraph, so this is an unusual provision, and there's got to be a construction given unless paragraph 2 applies, and it qualifies paragraph 8. But if you then go to paragraph 2, this order was made at a hearing without notice to the respondents. The respondents have a right to apply to the cast or vary discharge the order, see paragraph 7 below. Your construction in relation to that is that unless what? So do you say that simply because paragraph 2 gives the right, or do you say that unless paragraph 2 applies in the sense that they apply to the court to vary or discharge the order? What's your how do you say
the former,
this applies?
But the former proposition that my lord put to me, but the second as a fallback, it must mean one of those 2 things.
Right. Well, on the fallback, so on the former, I don't find at all attractive. You can try and persuade me otherwise, but I mean it's a pretty short point. On the latter, you are saying that it means that unless the respondents apply to the court to vary or discharge the order, then paragraph 8 applies. That's the fallback position you take.
That's the fallback position I take. And I accept that paragraph 7 applies. Sorry, bird just flew into my window. Paragraph 7 applies.
In any event.
In any event. And there can't be any question.
Now, all right. So let's assume that you're right in relation to that. Your clients didn't apply to vary or discharge the order immediately. They applied to vary or discharge the order. Let me just get my chronology. On the 4th of April.
Yes, I can't see that any particular criticism could be made of them for that. And to the extent this order, I mean, I haven't taken you through the authorities on the strict construction of the order because I've put them in my skeleton and I take
I accept that this has got a contempt order applied to it, so it's got to be strictly compliant. Now, notwithstanding that, I mean, I haven't shut you out making it full, but your first construction, notwithstanding strict construction, seems to me to deprive the order of all effect. The second construction doesn't, and that's why I'm engaging with it at the moment.
May I just, I won't take long, but let me just deal with the first construction first. I accept that the first construction deprives the order of all effect vis-a-vis paragraph 8, It doesn't deprive the entire order of.
No, of course that's right. No, of course not. It means that you've got a paragraph in the order which serves no effect. That paragraph 8, in other words.
Yeah. And whose lookout is that? Answer: it's the party that drafted it.
Well, even despite strict construction, one might also say that, let's put it this way, it's certainly not the construction which leaps off the page.
Well, that's my submission to you. You will accept it or not, your burden and your privilege.
Yeah, I mean, I accept it's got to be strictly compliant, so tick, but even on a strict construction. But I mean, when I say it's a point which, I mean, there is only so much you can say it, and I suspect you've said it in support of that first construction.
Yeah, quite.
Now, the second construction I'm engaging with.
Yeah.
Well, I'm engaging with because, you know, I can see where you're coming from. So let's just flow through it in relation to it. Now, there's obviously a time element in relation to this because the paragraph 8 requires within 48 hours to inform the et cetera, et cetera. So it's got a time limit. You've got to do this within 48 hours. And so paragraph 2, the order was made, and the respondent have a right to apply to vary or discharge the order. See paragraph 7 below, and paragraph sorry.
Well, my lord is ready.
Yes, sorry, I'm a bit slow. How does this tie in with paragraph 15?
Exactly. If that's the time period. Yes, exactly. This order does not make sense at all. So the idea that if I prefer your strict construction point 1, I deprive the order of any effect, that is the consequence of the manner in which this order has been drafted, because paragraph 7 makes it look does not set out the right to apply to discharge. It instead imposes another obligation, and of a completely different character, with which,
yeah, so your point in relation to this is that my instinctive matter is that I was reading paragraph 7 as if it was paragraph 15.
Yeah.
But
exactly.
And if that's the case, well, one gets it, but not otherwise. All
exactly.
Right. Well, I do now understand. Well, both the points that you make in relation to that. Okay, so that's your point on construction.
This order does not require me to do anything.
No, and in relation to the provision of information.
Yet, nonetheless, in relation to the provision of information, and nonetheless, my clients have complied with the only matter which they arguably had to do, which is the order at paragraph 7, inappropriately said to have been a time in relation to discharge, which, as my lord's already looked at, means that I can apply at any time to vary it.
Yeah.
These paragraphs simply do not make sense.
Yeah.
And that is because the numbering is completely out of whack, because the standard order wasn't followed.
Yeah, well, I mean, the standard order wasn't followed, and there wasn't then sufficient attention to making sure that the paragraphs tied together is the likely aspect of it.
Well, obvious. I mean, yeah, clearly, this is all holics. That I'm not suggesting for a moment that this has been drafted in a deliberately obfuscated way.
I understand the point, but you are saying if one's going to start saying that someone ought to go to prison in relation to this, it's got to be clear to them, and to use an expression I used earlier, it's as clear as mud. All right. Well, I think exactly. I now have
exactly
your points in relation to the construction of the order.
Yeah. The other points I have set out in relation to what you called the technical points. When I was before you the first time, I made my submission of source for the goose and source for the gander. I concede that the court has a discretion to cure a technical oversight in relation to service. I also say that the court should be slower to exercise that discretion it's one thing to get your jurisdiction application in a bit late. It's another thing to say, despite the fact I have made a serious technical shortcoming in relation to the service of a committal application, it should my client should nonetheless be the subject to it. This relates to the clear as mud point, my lord.
Yeah.
One of the things that an applicant for committal is required to do is to enumerate the allegation of contempt. The applicants here cannot decide what the allegation is. There's a difference between the application, which lists 3 items in contempt, and Mr. Sandilla's witness statement, which says there's only 1. You've got the references in my.
Yeah, can I just for my own note, because I want to get this. Let me just. Can you just?
Yeah. Do you want the page number?
No, I want to do one other thing first, which is just make a note myself. And can you just give me just remind me where this is in your skeleton?
Yeah. This is at paragraph 112.
On page
20, is it in the bundle? It's on page 24 of the internal page 24 of the skeleton.
Yeah, I'm sorry, I'm working for you, the internal ones. Right. Can we just turn these up? What the substance of it? So can we just look at the 3 allegations at what's B737? What's the bundle reference?
It's actually page 38, but 37 is the first page of it. That is the amended application. We should start at 37 though, really.
Yeah.
The first thing to say is my clients only had a couple of weeks notice of this application, and much fewer from the last time we were at the hearing. You'll see that he initially wasn't served with this application. If you look at the serving parties on page 37, it's against Arj and Marj. And on the 6th of May, you see from the stamp at the top, which is when the amendment was agreed.
I think I've got your points about timing. Yeah. I'm just looking about what I regard as so they breached the terms of the order by 25,000. 2 okay, that's what they said there. And then the 1 act at page 571, can we just look at that?
Paragraph 34.
Yeah, okay. Okay.
I don't know how much appetite my lord has for my technical points. One of the odd additions to the standard order was an obligation on my learned friend to serve these documents personally.
Right.
The certificates of service show they sent them with a courier. So, I mean, again, my lord,
I doubt you're going to win or lose the application.
Yeah, well, as I said, I don't pretend that my lord doesn't.
Is there? I mean, I will reread these matters because I'm not going to give judgment this afternoon. But is there anything you want to add to your skeleton in relation to these matters?
My primary objective in addressing you was to take you through paragraph 8, paragraph 2, paragraph 7, paragraph.
Yeah, well, I now understand the points you made.
I might be able to save some time, but maybe just have a quick look at what I might be able to cut something out. I think, Lord, there are the sort of the technical points, if I can put it that way, are put in much greater detail in the first skeleton. I've summarised them in the second skeleton, but as I said, the main thing on which I wanted to address you today, what was in relation to construction. In relation to what information has been provided, you'll have read the statements that my client has put in. My client said what he said.
Just taking this short, if we get that far, the gravamen of the complaint which is made against you by Miss Vigilani is fairly straightforward, which is that broad terms, you said things were all encumbered. Information comes to light showing they're not. You put in explanations. You haven't been prepared to turn up to be cross-examined. In those circumstances, I should disregard the explanations, and that leads to a finding that you haven't complied with what on her construction 8 and 10 requires. So I mean that's the gravamen in relation to
my response to that is Miss Vigilani wants to hunt with the hare and run with the hounds, or run with the hare and hunt with the hounds, whichever way around it is. On the one hand, she says you should ignore all of this. On the other hand, she says, well, I quite wanted to cross-examine him. And if we are seriously are in it, and she hasn't applied for a trial of contempt or directions in relation to a hearing for contempt. She's just applied for the order. And she hasn't actually still, despite the fact she addressed you for quite some time, told you what she wants. She says she wants a reference to the Attorney General and a fine. But the idea that I now am supposed to respond to this, I mean, what fine does she want?
I was trying to get that. I mean, just in relation to that, I thought there was a recent decision which I confess I can't immediately find, but I thought there was a recent decision which gave some guidance as to the approach in contempt general cases, but I can't find it. If either of you were aware of that or become aware of it as a result of researches, PDQ,
Your Honour,
please.
As I said, I've appeared before the Court of Appeal in Gulf Rings, and it's for the court to decide the fine. It's obviously not my decision to decide what fine the court is going to apply to a contemner.
It's not Gulf Wings. I think that's a 2023 decision, isn't it?
Yes, I'm saying I will look for the more recent decision, but it is for the court to set the fine, not for me to tell you what it should be, really.
No, I will hear from you shortly. I'm at the moment just on Mr. Fierce Eagle is saying rightly or wrongly, you haven't said what it is. I'm just asking him to respond to the proposition which I put to Miss Vigilani, which is that in the circumstances of this case, if what is wanted is the information, one might have thought that a suspensive condition of a fine would be more appropriate. And I'm simply inviting Mr. Fierce Eagle to comment on that point, which, as I said, put to Miss Vigilani.
Because I haven't taken instructions on that because it wasn't what was sought. My primary position would have been, I mean, the court was obviously very keen to hear all these applications today. My primary position was going to be, before we got too far down, or before we started rolling down the track, was that it's invidious for you to consider the question of contempt at all in a vacuum in circumstances where, if you accept my primary case, this order is going to have been set aside, because obviously what you're considering in an allegation of contempt is one of guilty mind. And the quality of the breach of the court's order, I accept that if you find against me on every point I've made to you so far, the fact that the order was not complied with whilst it was in existence, if you find against me on that, is nonetheless a breach potentially punishable by contempt. But obviously, the extent to which the court would be interested in making such a punishment is going to be affected by whether or not the order should have been made in the first place, and whether or not the order in fact stands.
Yeah, okay. Anything more you want to say on contempt now, Mr. Fierce Eagle?
Not on contempt, providing as I know my lord will, he will look at the matters in my skeleton, both in relation to what I've said previously, because, for example, I didn't address you on the effect of the arbitration clause, etc., because it was all in the skeleton, which I hope I safely took as read. But it's as I say, it's in the skeletons, and my main concern was on construction.
Okay, all right, right, Ms. Vigilani, reply on contempt.
Mr. Jummer will not be familiar with the standard form of order. He's received your order on the 10th of March. That order is as clear as day. I don't understand the points being advanced that it's as clear as mud. It's not clear as mud at all. paragraph 8 clearly says unless paragraph 2 applies. My learned friend is trying to suggest that freezing orders issued by the DISC courts can just be ignored if someone thinks that they can go and apply at some point in time, whenever they fancy. They can just ignore the order. I mean, it's just absurd.
Well, but just let's just take this down a notch, Miss Bijolani. Paragraph 8 starts off, and paragraph 8 is a penal order, and you presumably accept the general proposition that penal orders need to be construed strictly.
Yes.
Paragraph 8 says, unless paragraph 2 applies. So one looks to paragraph 2 and says, well, what does that mean? This order was made at a hearing without notice to the respondents. The respondents have a right to apply to the court to vary or discharge the order. See paragraph 7 below. What do you say those words, unless paragraph 2 applies, mean? What do they mean?
That means unless an application is made to have the order set aside or discharged. And that is what it says. It says, this order was made at a hearing without notice. The respondents have a right to apply to the court to vary or discharge. Surely the solicitors have the common sense to tell their client.
So what do the words see paragraph 7 below? What's that doing in paragraph 2?
It's well, presumably that's just there by error. But what is clear is the start of paragraph 2.
Well, sorry, is there by error? I mean, I think this is a draft which is produced by the claimant, but what should see paragraph 7 below say?
I haven't identified the relevant provision in the standard form, but what I am saying is that anyone reading this order would realise, and their solicitors would have told them, that unless there's an application to vary or discharge, you have to comply. It'd be a very, very dangerous and dicey situation for someone to take a view that, it's just not clear. I'm just not going to comply.
Okay. Well, let's say, so you can't tell me. So do you accept that paragraph 7 below is wrong?
It seems I haven't had the chance to look at it properly by reference to the standard form. But
I'm sorry, I don't understand that. This argument is set out in Mr. Fierce Eagle's skeleton argument.
Well, what I'm saying is that it's a settled point of law that an order of a court has to be complied with unless it's varied or discharged.
We're not on that point, Ms. Vigilante. We're on the point of what you can't tell me what the words see paragraph 7 below should be saying.
But no one's telling me what those words do mean. Or no one is saying what the first 2 sentences of the paragraph mean. It's quite clear. It's basically saying that
you having had 3 months or 2 months to look at this can't tell me what the words see paragraph 7 below are meant to mean.
I had explained it's a typo, but it's
settled typo law. For what?
I haven't had the chance to look at it by reference to the order. But
well, Mr. Joy, I'm sorry, you are telling me that you over 2 months, haven't been able to say what this typo is.
That is not the case, actually. Your Honour, this ambush happened a week ago. Okay, this ambush happened a week ago.
Well, you've had
These
a week,
points were
and you
not
can't tell
raised.
me what the typo is.
Okay, I've made my submissions.
I'm sorry, Miss
I've made my submissions.
I mean, if you want to have further time to tell me what the typo is, how long does it take to say what the typo is?
I don't think this line of questioning is helpful. I've made my submissions on the point.
Well, what is your point?
My point is that the order is clear and it has to be complied with unless it's varied or discharged.
Right. So you can't. Do you accept that you can't give any meaning to the words see paragraph 7 below?
I don't know because I haven't checked. I'm taking the position that the order is clear. The solicitors acting for the respondents must have told Mr. Jimmer what he needs to do. They either didn't or he ignored them.
Well, we've taken this, as you say, as far as we can. Now, the second question I've got for you is this. The respondents, you say the order's clear. The respondents have a right to apply to the court to vary or discharge the order. there aren't any words meaning given, see paragraph 7 below. What does that mean in terms of the obligation in paragraph 8? Does it suspend the application in paragraph 8?
No, because it's settled law that a court order has to be complied with until such time as an order varying or discharging it is made. And that, if you want me to take you to one authority, can be found at 1725 by Sir Jeremy Cook.
There's no dispute. Indeed, it was conceded by Mr. Fairseagle just now that the fact that the order may be set aside or varied doesn't affect the need to comply with it. There's no dispute about that. That's accepted.
I don't
But
think it is
paragraph
accepted
8,
by him. I don't think it
sorry?
is. I don't think he does accept that.
Well, paragraph 8 says, unless paragraph 2 applies. Now, do you say there's a typo in relation to those words?
I say, unless paragraph 2 applies and an order is made varying or discharging the order, Mr. Jummer has to comply with paragraph 8.
Right. So the words which you say that this should be construed as is, unless paragraph 2 applies with a consequent variation, the respondents must. That's how you say this should be obviously complied. This could be, yes, should be construed.
Absolutely.
Okay. All right. Fine. Now, in relation to the question of what the allegations are of contempt, what, if anything, do you say about the difference between one allegation and 3 allegations?
Well, it's a consistent theme. I'm not quite clear as to what you mean. I mean, the allegations are that he, one, didn't comply within the 48 hours or within the time period set by paragraph 10 and has not complied at all as at today. There's been no compliance.
Right. Okay. And do you rely on the points which are made in relation to that? Very well. All right. Are there any other points that you want to make in reply?
There are. My learned friend misleads you on the rules of the court yet again. RDC 9.54 deals with service out of the DIFC or Dubai. Where a claim form is to be served out of the DIFC or any other method permitted, it's to be served in accordance with the relevant jurisdiction, and that applies also in the case of committal orders. We're dealing with respondents who are in Hong Kong and the Cayman Islands. The orders have been served in accordance with the laws of those jurisdictions. As I took you to earlier, the statements of Walkers at 980 and the witness statement from the lawyer in Hong Kong at 991.
I think the point which was being made is that the order required personal service. I mean, I have to say, I don't think that much is going to turn on this particular point, but I may be wrong. Oh, I see. So your point is this court will serve the application notes on the respondents in accordance with Rule 25.41, and that therefore means that when you're dealing with overseas, you deal with in accordance with the rules out there. That's your point in relation to 20.
That's correct.
Okay, right. Well, I've got that point.
No other points from me.
Well, all right. Well, it may not surprise you to know that my original hope that I was going to give judgment this afternoon is not one which I'm going to go through with. However, I am anxious to deal with this, and I propose to list it for an oral judgment at 10 a.m. Gulf Standard Time next coming Tuesday, which I think is the 27th of June. And I will also deal then with the costs issues and the schedules, which were sent to me very shortly beforehand. And so what I will be doing is giving an oral judgment in relation to the matters before me, and then dealing with the issues of costs. And insofar as relevant, I'll also be giving consequential directions. That's what I propose to do. I wish you all a very good weekend.
May I just very briefly, in a couple of hours, I'm getting on a flight to Lake Garda, and I'm there next week. I'm not saying I can't come, but I'm not sure what sort of internet I'm going to have. I'm on a boat for some of it.
Well, can I say this? I'm for a variety of reasons, I'm afraid, to do with the desire to get this judgment out and actually some other commitments in the court. I'm very unwilling not to give an oral judgment.
I understand the giving of the judgment. It's just some other argument points that I'm slightly concerned about.
I mean, if it is absolutely necessary, I mean, first of all, it seems to me that if at all possible, if you can't do it, there should be an alternative representative. If absolutely necessary, I will deal with issues of costs following written representations afterwards. But I would very much prefer to deal with all matters on Tuesday morning.
Might you make a dispensation in terms of what I might be wearing, my lord?
Oh, if you're going to be wearing a Hawaiian shirt and shorts, then I won't not listen to you.
It won't be that, but I've got some logistical problems in terms of luggage. And you, as far as I'm concerned, I shall hear you. If you want to have your camera off so we can't see what you consider appropriate to Lake Garda, that's a matter of other things. Ms. Vigilani, does this cause you any particular problems next Tuesday?
Sorry, could I just check what time you're proposing?
I was proposing 10 o'clock, 10 a.m. Gulf Standard Time.
Yes, that's fine with me.
Very good.
Can I just make one point in relation to the former freezing order? If you are proposing to amend the freezing order further, I would like to bring to your attention an amendment on page 2760, a suggested amendment in relation to the business exception. And that has been put before you because there is a concern that with the wording that you put in your earlier order, that the respondents may be able to use that wording to have the attachment on the real estate assets in Dubai discharged. And that's on the advice of
Lord, but of course I can read it. I haven't seen this, but of course I can read it before Tuesday.
Well, the order is going to continue in its present form until Tuesday, and I will have a look at this. And see what.
When was this added to? Can I ask Ms. Vigilani when this was added to the
we don't need to have this online. If it's if the order continues after Tuesday, and if there's a dispute about it, we can discuss that briefly on Tuesday. I've noted it down. All right, thank you both, and thank you all very much indeed, and I will look forward to seeing you on Tuesday at 10 o'clock Gulf Standard Time. Thank you.